Good afternoon. The Appellate Division First Department is now in session. Welcome to the First Department. What I'll do is I will call the full calendar and the time that has been allocated to each case. There's no need for you to introduce yourselves until your case is called in the order in which time has been allocated for oral argument. First case on the calendar is People versus Ricky Moore, and that case is submitted. Henry versus Split Rock, that case is submitted. R Genesis versus Jarrell E is submitted. Pharrell Limousine versus Macro Consultants. Appellant Pharrell Limousine has been allocated 5 minutes and 2 in rebuttal. Respondent has been allocated 5 minutes. Dorador versus Trump Plaza, R&J Company and Aztec. Appellant Trump Palace has been allocated 7 minutes and 3 in rebuttal. Respondents R&J and Aztec have been allocated 6 minutes each. Vista Engineering versus Everest Indemnity. Appellant Everest has been allocated 6 minutes and 2 in rebuttal. Vista respondent gets 6 minutes. People versus Justin Ortiz is submitted. Germain versus Ness Lemmer Company and Luca versus American International and Ness Lemmer. Those 2 cases have been consolidated for argument. Appellant Ness Lemmer Company has been allocated 6 minutes and 2 in rebuttal. Jermaine Luca respondents has been allocated 6 minutes. Coxum versus Granville is submitted. G Children is submitted. Correction Officers versus City of New York. Appellant City has been allocated 7 minutes and 3 in rebuttal. Correction Officers gets 7 minutes. Benitez versus City of New York. Appellant Benitez gets 5 minutes and 2 in rebuttal. City of New York gets 5 minutes. Johnson versus Asbury. Appellant Asbury gets 6 minutes and 2 in rebuttal. Respondent Johnson gets 6 minutes. Santana versus MMF 1212 Associates is submitted. Patterson versus NXK Corporation. Appellant Patterson gets 4 minutes and 1 in rebuttal. Respondent NXK gets 4 minutes. People versus Williams is submitted. Jewish Press versus NYPD. Appellant Jewish Press gets 5 minutes and 1 in rebuttal. NYPD gets 5 minutes. Walsh versus Pisano is submitted. Share versus Turing Respondent. Appellant Share gets 6 minutes and 2 in rebuttal. Turing Housing gets 6 minutes. And last, Avenue A versus Board of Managers Health House is submitted. First case for argument is Pharrell Limousine versus Macro Consultant.
May it please the court, my name is Harlan Lazarus and I represent the plaintiff appellants Pharrell Limousine. Your honors, this matter arises out of a building project in Long Island City, wherein my client was the property owner and in pertinent part, Macro Consultant was the consultant to Pharrell in connection with the project. Macro and Pharrell signed an agreement in October of 2010.
Mr. Lazarus, we're familiar with the facts. The original, and I'm a little bit confused because in your briefs and in your pleadings, you claim to have paid $2.5 million, but the contract itself called for a lot less. So just with respect to the breach of contract claim, can you tell us what the nature of the agreement was with respect to remuneration for the defendant?
Yes. The defendants were paid, I believe it was on an hourly basis over time, and as the project took an extended period of time, there were payments likely over and above that which may have been recorded in the document.
So was that part of an oral agreement? Was that part of, because clearly these payments were outside the confines of the contract.
The payments to Macro?
Yes.
No, Your Honor, all of the payments to Macro were within the confines of the contract. It may be that there are pieces of the contract or billings related to the contract that are not part of the record, but the basic contract, the contract wherein we have a claim, is the principal exhibit to the complaint, and is, of course, in the record on appeal.
So let me ask you this way, because you clearly have a breach of contract claim and you have an unjust enrichment claim. Now, you cannot maintain both if we're talking about the same exact terms in the underlying contract. So what were the defendant's obligation outside that contract?
Okay.
That would entitle you to sue for unjust enrichment as not duplicative of the contract.
If Your Honors were to uphold the breach of contract claim, then the unjust enrichment claim is duplicative, period. There's no double dipping, Your Honor. We proceeded, or we filed the unjust enrichment claim essentially on the theory that the defendants would maintain that there was no express contract. But we believe principally that there is an express contract as it relates to the failure to get or to properly supervise yet another contractor towards the end of getting this ICAP approval. And if I may go back to my argument, or Your Honors may ask any questions, of course, you prefer.
No, I will, because I was a little concerned. Obviously, you're not allowed to maintain a duplicative unjust enrichment claim. But you're telling us that at this posture, without having conducted discovery, it's a dismissal motion. So you will be withdrawing your unjust enrichment claim if your breach of contract claim is sustained. Am I correct in that?
1,000% correct, okay. Your Honor.
Thank you, counsel.
If any of the other justices have questions, I will address them. Otherwise, I will just briefly repeat that which is in the filings made with the court. Macro essentially looks to avoid a responsibility here because there is no express reference to Macro in the Macro contract document. What that ignores is—
Judge Scarpula, isn't that first contract have only to do with phase one? It says nothing in that first contract about, it says you will hire people to do it. You did hire someone to do it. Carrick Moore was supposed to do it, and you sued Carrick Moore. You got the person in who had the responsibility, contractual responsibility to do it. So I don't understand how you can argue breach of contract when that contract only dealt with the first phase of the process. You might have something else, as you were saying, that there was work done outside the contract, but I don't see how that contract applies.
Your Honor, Justice Scarpula, the actual agreement of Macro and Farrell was that Macro was going to supervise the phase one of the project. And although the ICAP application is not expressly mentioned in the Macro contract document, that Macro had responsibilities towards ICAP is most firmly evidenced by the fact that Macro filed the initial ICAP application in January of 2012 and was addressed by ICAP or the city as the builder's representative. And that application.
So approval, Mr. Lazarus, so approval of the ICAP application is contained within the quote pre-development planning and approval phase of the project, unquote.
Yes, it is contained within that. Yes, it is contained.
So can you tell me where in the contract it actually says that? Because I didn't see it.
It does not.
It doesn't say it. Let's agree. It doesn't say that in the contract.
It does not say that, but the fact, Your Honor, is that it was within the realm of the contract is evidenced by, as I mentioned a moment ago, the fact that the ICAP application was filed by Macro, and as we outlined rather extensively in the complaint and in the brief, throughout the engagement, past the engagement of Carrickmore, the contractor who was solely responsible for getting the approval, Macro is actively involved on a regular basis with my client and with the project.
Thank you, Mr. Lazarus.
Okay.
You have a question? Okay.
A quick one. Counsel, I thought you were going to argue that there was an oral agreement and point to the indicia of an agreement by pointing to the consideration that was paid, but you're arguing something entirely different, or am I wrong?
We are not proceeding on an oral agreement. We're proceeding on the express written contract and Macro's obligation to properly supervise all persons in phase one, including Carrickmore, which supervision is evidenced by their own conduct.
So you're saying that the 2.5 million was paid pursuant to that contract?
The money's paid, yes, the money's paid to Macro were paid pursuant to the Macro contract.
Okay. Thank you, Mr. Lazarus. Let me hear from your opponent, and you have a couple of minutes in rebuttal.
Understood.
Good afternoon, Donna Margie of Black Margie and Sanford on behalf of respondents Macro.
Mr. G, one question that we have, which seems to be somewhat confusing. You filed the ICAP application, correct?
Correct.
And you filed that pursuant to your obligations under the phase one agreement or something else?
No, my clients filed the ICAP, initial ICAP application because at that time, Carrickmore had not been engaged, Crescent had not been engaged, and Mr. Altman had not been engaged. So as a matter of course, Macro filed the initial application, but what is at issue here is the actual filing of the final ICAP application within the 1 year period from the.
What's confusing to me is that there were a series of exchanges, email exchanges, where the plaintiff is asking, have all of the filings taken place? And they were addressed to you. Your response was, or your client's response was that Caramount had filed everything that needed to be filed. So you assure plaintiff that the filings had taken place. Did you do that out of the goodness of your heart? Did you do that pursuant to contract or something else?
If I may just clarify, what the emails state is that they asked for the deadline of the 1 year expiration from the issuance of the building permit. So my client stated the dates, and then Pharrell indicated that they wanted to keep it on our radar, which means Pharrell. Right. And Macro responded that it was advised by Carrickmore that everything was submitted. So not that they were checking whether or not Carrickmore submitted
but
anything.
The actual language of the email is, this is Miss Marguerite Farrell of Plaintiff asking Patricia Greenwald of Macro, quote, can you please advise where we stand on the status of our ICAP filing? There's a typo there. And Greenwald's reply was, quote, I understand that the ICAP filing has been handled by Crescent and approved. So you assure plaintiff that it was approved. Farrell told Greenwood, please keep this in our radar. Once the building permit is issued, we have 1 year to file the final application, unquote. And that's a record 670. So you obviously had some sort of obligation, because it's not like you responded or Ms. Greenwald responded, no, we're no longer obligated to follow up on the ICAP application. You said, my understanding was it was filed, and in response to the question about whether you should maintain Farrell Limousine informed about the status, you didn't deny that you were obligated to do that. So I'm confused.
Well, a reading of the emails, Your Honor, indicates that, Ms. Patricia Greenwald was just responding to the question that was asked. And then later on in an email that plaintiff references of August 26, 2014, Mrs. Greenwald states that Carrickmore has confirmed that the final application was filed. At the end of the day, Macro was not in privity of contract with Crescent, Carrickmore, or Altman. Farrell was in privity of contract with all three entities.
But counsel, if I may, on August 26th, Farrell asks, we are up to date on everything we need to be doing, correct? And then Greenwald replies, yes, we are up to date on all paperwork. So the we seems to be an inclusive we, doesn't it?
Well, the we, what is identified in we're up to date on all paperwork, the paperwork is not identified. Macro's agreement doesn't reference ICAP. Farrell is a business savvy entity. They created 3 contracts that specifically reference ICAP. Nothing in the 6-page macro agreement references ICAP. Nowhere over the period of a few years during their engagement did they amend the macro agreement to include any reference to ICAP.
There's no issues of fact here, given the payments that were made, given the correspondence between the parties, and given the fact that this filing had to be absolutely done within 1 year or else the tax benefits vanished. You're maintaining there's no issues of fact?
No, there are no issues of fact, because the documents and the Carrickmore agreement, the macro agreement, all of the agreements, which provisions are specifically included in the complaint, and plaintiff annexes those documents to the complaint.
Yeah.
All of the documents are clear.
Counsel, the ultimately, by the way, this is a 3211 motion, right? This is a dismissal motion, correct, right?
Correct.
So who ultimately turned over the report from Crescent to plaintiff?
The report from Crescent to plaintiff was given, well, Macro had a copy of it, obviously. Carrickmore obviously had a copy of it. And they provided it to plaintiff directly because they were in contract with Carrickmore. Crescent was in contract with Carrickmore.
But it was Ms. Greenwald who emailed Ms. Farrell on February 11th of 2015 saying, please find attached the report from Crescent, etc., indicating the work has continued since the project was first with New York City and qualified as an ICAP project. And that's on record at 701. So
that's sorry, Your Honor.
No.
That's fine. Macro obviously, as part of its involvement in the overall project as a whole, is going to communicate with some extrinsic items regarding ICAP and other items of the project. But the obligations are, with respect to each party, are clearly identified in the different written agreements, which are also included as allegations in the complaint.
Thank you, Ms. Margie. Thank you so much.
Thank you, Your Honors.
Mr. Lazarus, you have 2 minutes.
Thank you. Thank you, Justices. I want to be very clear with the court that the breach here is not a breach of the obligation to get the ICAP permit, but a breach of the obligation that Macro signed on for to furnish project management services and to perform such services at all times in the best interest of Farrell.
Counsel, this is Judge Scarpula. I just want to make this clear again, that if we find that that wasn't part, supervising the actual getting of the ICAP, that wasn't part of phase one, and your contract deals with phase one, you're telling us you have no other claim?
Mike, that is.
That's what I thought I heard you say. I just want to make it clear for the record. So if we dismiss the breach of contract claim, you're done.
Well, I have the unjust enrichment claim then.
Right, but so that's what I'm saying. What is the essence of your unjust enrichment claim?
I paid them $2.5 million for the things that I just referred to, Your Honor. Which
even if they're not specifically in that phase one contract, you were paying them to do continuously even after that phase one was done. That's your claim, correct?
Your Honor, I'm paying them for phase one, which included ICAP, and the agreement with Macro agrees to work closely with client, contractors, architects, engineers, and specialty consultants. This is exactly what happened here. They worked closely with Macro and messed it up, Your Honor. They as Justice Acosta has pointed out, they specifically communicated information indicating that they knew what the cutoff date was.
Counsel, that might give you a negligent misrepresentation claim, but it definitely doesn't give you a breach of contract claim if you don't have a contractual obligation. That's why I keep asking you whether or not you have something else besides the breach of contract claim.
Your Honor, the answer is I have my unjust enrichment claim or I have my breach of contract claim. There's no negligent misrepresentation claim or similar. I believe, and of course I've argued and I won't take up any more time, that the parameter of this contract expressly included the obligation to supervise in Farrell's best interest. That obligation was breached by the conduct of Macro as it relates to ICAP, and that's why we're entitled to go forward with the claim as against ICAP. Thank you.
Thank you, Mr. Lazarus. Thank you both.
Thank you, Your Honors.
Next case is Dorador versus Trump Palace, R&J Company, and Aztec.
May it please the court. My name is John Sandercock, and I represent the Trump Palace condominium. This action arises out of an injury in 2007 to Ivan Dorador, who was granted partial summary judgment against Trump Palace on the issue of liability under the labor law. We were in this court about 6 years ago. This court held then that Dorador's work was covered by the labor law.
We're familiar with the procedural history, Mr. Sandercock. Can you tell me, so you believe that at the very least you were entitled to summary judgment with respect to your tenant, right? R&J?
Yes.
I mean, I'm sorry, the condo unit owner.
Under the condominium bylaws, we're entitled to indemnification from the unit owner, and the lessee, A&P, assumed all of the unit owner's obligations. So there shouldn't be any issue that we're entitled to indemnification in that respect.
But only from R&J, not from A&P, right?
Well,
you had no privity of contract with A&P.
That's true, but it was a very close relationship. The A&P took over the entire space and signed documents agreeing to assume all of R&J's obligations under the condominium bylaws.
Okay.
And we've been through bankruptcy together in this, and R&J and A&P have been deemed to be united in interest. So yes, there's no privity of contract, but there is a unity of interest there.
But it is R&J that has to indemnify you, right? Even based on the bankruptcy court order, that's the case.
R&J is the unit owner, and they have the obligation to indemnify.
Okay.
Okay. The obligation to indemnify arises out of Section 5.2 of the condominium bylaws. It says the unit owner shall be deemed to agree to hold the condominium harmless against liability for any repairs made in or to the unit. And
Yeah.
the motion court found that there were questions of fact about this, which are
Right. So you feel there are no questions of fact that if you read the indemnification provision in the condos bylaws, basically you're entitled to indemnification from the unit owner based on that plain language.
That's correct.
Okay, we got that.
Okay. We are also seeking contractual indemnification from the plaintiff's employer, Aztec Metal Maintenance Corporation.
Right.
And this is based on contracts between Trump Palace and Aztec, as well as a contract between A&P and Aztec. In fact, the plaintiff was working on a job for A&P at the time. He was polishing.
But they were not employed by A&P, right? The plaintiff was employed by Aztec.
Yes, he was employed by Aztec. He was working on a contract for A&P. And
But that was a service agreement that between Aztec and A&P, right?
yes.
Okay. Okay, thank you, Mr. Sandercock. Let me hear from the other side.
Your Honor, Richard Imbrogno of Marshall Dennehy representing R&J and A&P. As Your Honor pointed out, the contractual obligation is that of R&J. We believe that the indemnification provision in the bylaws refers to repair but not to cleaning. And we think that there is...
But hasn't that issue been decided, counsel? Stripping, cleaning, and lacquering is repair.
Well, I don't believe it's been determined. I mean, when the case was before Your Honors on the labor law issue, it was a determination that labor law applied because it was cleaning. Here, this particular indemnification provision does not refer to cleaning, and that there is.
Well, that was only because, but the issue of cleaning only came in because the question was whether he was engaging in cleaning and not in routine maintenance outside the statute's coverage, right? So that was an analysis based on the labor law, not the provision, not the indemnity provision in the bylaws.
Right, but the bylaws do not refer to cleaning, and we believe that on the face of it, it doesn't apply to this particular set of circumstances. If there is any ambiguity to that, and we don't think there is, but if there is any ambiguity, it's exactly what the lower court said, that in the presence of ambiguity, there would be issues of fact that would have to be resolved after further discovery and potentially a trial or maybe a second summary judgment once the circumstances of the particular bylaws had been explored. But on its face, this is not the same situation as the labor law, which refers to cleaning. This does not refer to cleaning at all. And the issue of whether it's routine maintenance or something else, that may or may not be the case, but it's not what the bylaw sets as the test. And we believe that on its face, it doesn't apply. But if there there is and to the extent that there is any issue about that, it's a tribal issue, as the lower court found.
So just so that I understand this, so your position is that stripping, cleaning, and re-lacquering is not repair, right? So it's certainly not under the lease that you have with that RJ has with the condo. It is not alterations, improvements, additions, or repair.
That's correct, Your Honor.
Okay.
That's the position.
Thank you, counsel.
Thank you, Your Honor.
Good afternoon, Your Honor. Jonathan Schaub for the respondent, Aztec Metal Maintenance Corporation. The simple fact is that in this case, Trump has not identified a single contract that actually obligates Aztec to provide indemnification for plaintiff's injuries in this case. The entire claim is predicated on the Marble Maintenance Rider, and if we take a look at that document, it's an undated document. It doesn't have a start term or an end term, and is not accompanied by the underlying agreement to which it refers. And on that basis alone, it can't furnish a grounds for indemnification. And then looking at the actual text of the Marble Maintenance Rider, it can't show a clear and unmistakable intent to provide indemnification in this case. And look, it's a point you hit on, Justice Acosta, that the agreement, the rider, is a purported agreement between Aztec and Trump. The plaintiff was injured while performing work pursuant to an entirely separate agreement between Aztec and A&P. The rider refers to Marble Maintenance. The plaintiff was injured performing polishing of brass. The Marble Maintenance Agreement refers to work on the interior of the premises, the lobby particularly, and the plaintiff was injured on the exterior of the building, polishing the outside of R&J's commercial unit. So the parties don't align. Aztec, it's A&P, and Trump, that's not in alignment. The work, marble versus brass, isn't in alignment, and the location of the accident isn't in alignment. So you can't say that there's a clear and unmistakable intent to provide indemnification on that fact. There's no reasonable interpretation of this contract that gets you to that point. It seems that Trump has basically focused on the notion that the rider refers to the word operations in it, but operations is preceded by the word the, and at the risk of sounding pedantic
what about the issue of failure to procure insurance?
Yeah, so the court, the motion for re-argument, the Supreme Court did not abuse its discretion in granting re-argument. It correctly found that the third cause of action really sounded in breach of contract, or in indemnification rather than breach of the contract for failure to procure insurance. The relief sought was for indemnification and contribution, which is not a proper remedy for breach of contract for failure to procure insurance. Under Chastigway, the actual remedy is the out-of-pocket expenses. And even if it was a claim for breach of contract for failure to procure insurance, that claim can't stand because it's grounded in the A&P Aztec contract. And if we look at that contract, there's no right in there whatsoever.
So it doesn't require you to get insurance for the condo, right?
It doesn't require us to procure insurance for Trump, and they can't claim AI status because they haven't identified a contract requiring that, nor are they a third-party beneficiary. Okay. And in any event, the claim pleads damages that aren't available because they can't obtain contribution and indemnification. They can only have out-of-pocket expenses.
Okay. Great.
Thank you.
Thank you so much, Mr. Shaw.
Your Honors, there is an additional contract requiring Aztec to indemnify A&P for work arising out of metal maintenance. That
A&P, and that's a service agreement that I alluded to before, right?
It's a vendor recognition form or agreement. It's on page 1287 of the record, and it was not available to any of us when we moved for summary judgment against Aztec. A&P turned it up as a result of a search later on. We submitted it in our with our reply papers. Judge Leibowitz did not refer to it, and that.
Well, he didn't have it, right?
No, he had it. It was we attached.
Oh, you submitted it in reply to him.
To our reply to Aztec included this agreement, which was unavailable when we made the motion. The presence of that agreement, plus, several other issues of fact concerning, conflicting affidavits between the general manager of the condominium and the president of Aztec, raised.
Yeah, but those claims are those claims. I'm sorry. Go ahead.
I'm just saying there are issues of fact that Judge Leibowitz overlooked, and he should not have granted Aztec's motion, cross motion for summary judgment.
Okay.
Acknowledge that there are questions of fact regarding Aztec.
Okay. Thank you so much. Thank you all.
Thank you very much.
Thank you, Your Honor.
Vista Engineering.
Good afternoon, Your Honor. It's Ann Odelson from Kennedy's on behalf of Appellant Everest. Just
You
want
may
to make
proceed, Ms. Odelson.
Oh, thank you. I just wanted to make sure everything was working correctly. So the long and the short of it is this is a contribution action by Vista seeking additional insured status under the Everest policy issued to East Coast Painting. Everest issued a disclaimer based on an action over exclusion that bars coverage for the claims asserted where one of East Coast's employees is injured on a construction site. There was an issue about whether that disclaimer was timely. Initially, the trial court said that because the policy wasn't issued or delivered in New York, Everest could rely on the disclaimer. Then right before we were to argue the appeal, the Court of Appeals decision in Carlson came down, and then this department remanded the case back to the trial court to see if Everest's East Coast operations were substantial pursuant to what the court was holding in Carlson to find out whether 3420D applies. So here we are.
Why shouldn't it apply, given the fact? In fact, I thought that we had already decided that Everest policy covered risks in New York based on policy, on the policy's plain meaning, right? I mean, a lot of the work was in that Queensboro Plaza project?
Yes, it was the Queensboro. So there's no dispute. The risk is in New York. It's whether the insureds had a presence in New York, whether East Coast had a presence in New York. So the Everest policy that's on at issue right now is a renewal of a prior policy. So Everest knew about this construction project because it was continuing from the previous policy, and they needed coverage.
Well, let me ask you a question. Did East Coast perform any physical work in New Jersey?
Well, when they were renewing the policy, and that's part of the record, they said they basically made it seem like it was a mom and pop operation in New Jersey. And they told Everest, we have one supervisor in New Jersey. We have 8 laborers in New Jersey. We only have an office in New Jersey. So that's what Everest, when they were evaluating the risk on this, they charged them $8,700 for this policy. Vista's now when they moved for summary judgment, they attached all this deposition testimony showing that no, in fact, there was about 30 to 35 people from East Coast working on this. There was 20 workers at the time of plaintiff's accident.
Most of that work was being done in New York, right? In fact, all of the New York space for the staging and the coordination of the project, all of the workers were from the painting union, right? They were all New York based. So how can that not be a substantial New York based physical work?
I guess my thing is when you look at the comparison between the operations that DHL, the courier service, was performing in Carlson compared to it was Everest's understanding this one project that was going on. Is it really a substantial amount of work compared to the high standard they set forth with DHL, who's got thousands of deliveries in and out of New York State? But it also goes to our other argument that when they were applying, East Coast was applying for coverage, they did not let Everest know the substantial amount of workers that they had when Everest was evaluating the risk. They said 8 workers. And like I said, this was a policy that was being renewed. So, there's a question of whether did they just start hiring these workers for the second phase of the project when our policy was renewed, or were these workers on before? So what we did to say was, you know what, Vista, if you're saying this is right and they have all these workers there and they have a shanty, they didn't tell Everest this when they were calculating the risk. They would have charged a different premium perhaps, or they would have issued a different policy. But all we did was seek to amend our answer to include a counterclaim for rescission. And as this department has recently held, I don't have to prove I'm going to prevail on rescission, just that it's not devoid of merit. And we have an affidavit from our underwriter showing the application that they were applying for coverage. They didn't know about the risk or how many workers they had. And again, going back to, you look at how much they charged for this policy, and these are all New York, union workers. There would have been some kind of change, but at least we're allowed to explore that. So
Okay.
I think the court just did a different standard when they were finding about our motion to amend, and they denied that motion.
Okay, thank you, Ms. Alderson. Let me hear from respondent.
May it please the court, Brian Forbes from Baxter, Smith & Shapiro on behalf of plaintiff respondent, Vista Engineering. I'm going to start here with the substantial business. Defendant is arguing out of both sides of her mouth, essentially, by saying East Coast had too many workers in New York, but didn't have substantial business in New York. You can't claim that you should rescind the policy for having too many New York workers, but on the other hand, say that there wasn't substantial business in New York. The reality is that the Carlson decision, it did deal with a much larger company in DHL, and they did have arguably more operations in New York than East Coast. But as a percentage of their overall operations, East Coast did way more of a percentage of their work in New York than DHL did. DHL was a multinational company. They may have did a fraction of a percent of their overall work or gross revenue in New York. East Coast appears to have done all of their work in New York during the period of this policy.
Counsel, this is Jet Scarpula. I'd like you to address why we shouldn't let amendment to assert a misrepresentation in the application for insurance. Why is that not a good amendment?
Well, for several reasons, Your Honor. I think the big one here is we need to look at timing. This motion for an amendment was in response to a motion for summary judgment.
Well, I mean, we allow people to amend up in the Court of Appeals, and so assuming that we get over the timing, because a Court of Appeals case came out, which changed the whole flavor of this lawsuit. So why shouldn't we let the insurance company amend the answer?
So if we're going to move past the timing, there's still several reasons we shouldn't allow it. And I think the primary one is, if we take a look at the application, which is part of the record, it can be proven that A, these aren't misrepresentations to begin with, and B, they're not material. They can't be. One of the arguments that Everest Indemnity is making is that it's material, the amount of work that they did, the gross revenue that they did on the year of that renewal.
Well, not only the gross, counsel, not only the gross amount of work, but also apparently it was stated that you had 8 workers, where in fact you had, I think, 30 to 35 workers. So you were talking about percentage previously. So we're talking about the amount of workers, the amount of work that's going on. So I think it's a little bit more than, something that's trivial.
Well, Judge, if I may, it was on the application, I'm reading 12 workers. It's page 1473 of the record. There's a total of 12 persons listed on the application as working. Now, I will note of union shops or companies that employ union workers, their amount of workers fluctuate from week to week, month to month, depending on needs on a job. That is pretty standard practice. Let me just
interrupt you. If it is true that you had 36 workers, that's triple the risk of what you represented to the insurance company. So again, my question is, why shouldn't we allow the insurance company to amend to assert misrepresentation? Triple the risk is quite a big difference.
Well, A, this is not their workers' comp carrier, is one thing I would say. The second thing I would say is they have a premium audit to increase the audit at the end if the business level increases during the policy period. They specifically wrote in a premium audit to this policy that allows them to check gross receipts, to go through the full amount of business that was performed, to specifically increase the premiums. So how
you're
could
saying
they?
It's not necessary because there's already the remedy is already there within the policy.
Not only that, it's impossible for them to argue reliance if they specifically write into their policy that they will increase the premiums when business increases for that year. It becomes very difficult to say that they relied on this and would not have issued the policy but for some claim misrepresentation. And that's the standard here.
There's a fluctuation of workers. That's a natural part of the business.
In that's part of business, and it's also included as expected in this policy that the level and amount of business they're doing is going to fluctuate. That's why they include these premium audit endorsements that allow them, after the policy period ends, to audit the amount of gross receipts and then pay, either require a higher policy premium at the very end or refund portions of the policy premium.
Okay. All right. Let me hear back from Ms. Orelson.
Well, I guess my thing is, yes, they can audit a policy, but when you're applying for coverage, you're taking the insured at the face value that they're telling them what is going on. So when they're saying, okay, they knew about this project, like I said, so they were aware that the project was going on. They just they were not aware of the extent of the workers that were going on. The fact that they're union employees, this is completely going to increase the risk. So, and they were telling.
You now agree because Mr. Forbes seems to be indicating that you're arguing out of both sides, right? You're saying on the one hand that there wasn't a substantial business presence in New York. Well, there was, right? That was a lot of workers and a lot of projects and a lot of activity. Right?
I think respectfully, for the purposes of the Carlson analysis, yes, they had one job in New York, according to Everest, with a lot of workers. Does that mean they're doing substantial business in New York, like DHL, who's sending trucks in every single day all over the state of New York? No.
But was that the only project that they had in Queensboro process? They have a ton of projects with the MTA and the Transit Authority, right?
But Your Honor, that's what I'm saying. We were not aware of that. We thought it was one. If they're going to come back and they're going to say, yeah, they had a project here and the gross receipts were here and they had a project here, okay, that's something that we can consider with respect to the rescission.
But isn't that part of the audit that Mr. Forbes is talking about?
They're not required to do that audit if there's something that comes across that they're kind of like, what's going on? And usually that's in terms of renewal of the policy. But they're going.
Policy renewal, counsel?
I'm sorry?
Isn't this a policy renewal?
No, I'm sorry, Your Honor. If this policy right now is going to be renewed for another policy period. So right now they're going by what they're telling them at the time they're issuing this particular policy.
Right.
And what
but my question to you is, aren't you adequately protected because you have the absolute right to go and look yourself and see on a monthly basis what their receipts are, who they're hiring, what they're doing? So protected. If your argument is, I should have been able to charge more, and I'm saying to you, the policy protects you because you can go in every month and see whether you need to change the premium.
But I guess my thing is, yes, you can charge a higher premium, but if you are alerted to the fact that the insured is not being truthful, what insurance company you're trusting, it's an arm's, length, you're trusting with insured, but also rescission is.
Counsel, let me just interrupt you for a second. Really, the only issue then is whether in your cause of action, regardless of your moral feeling about it, is whether it was reasonably, you have reasonable reliance, whether there was a material misrepresentation and reasonable reliance. And if you bake into the policy the ability to check it, then I don't know how you can argue reasonable reliance.
But Your Honor, it's either you can rescind a policy and charge a higher premium. You might not write the policy that you're doing right now, or you might write a policy with different terms. So the fact I can do a premium audit and increase the policy because I'm finding out that 6 workers could, you had all of these workers, that doesn't cover me if there's already been a loss lodged under the policy and I wouldn't have covered the workers to begin with.
Okay. Thank you, Ms. Orelson. You've gone way over your time.
Thank you.
Thank you so much. Thank you all.
Thank you, Judge.
Before we hear from Jermaine and Nismuller, let me take a 1 minute break. Have a serious back issue here. Okay, we ready to go?
May it please the court. Can you hear me all right? Your Honor?
Yes, I can. So Jermaine and Luca versus Nestle Moore Company and American International. Let me first hear from appellant Nestle Moore.
Peter D'Annunzio of Clyde & Co. on behalf of the appellant. Your Honor, it is an uncontested fact here that the appellant has not been authorized to conduct business in the state of New York for over 20 years prior to plaintiff's attempt to effect service, according to BCL 306. The single fact is dispositive in the instant case and requires reversal as a matter of law because of plaintiff's failure to comply with Section 307 of New York's Business Corporations Law. To hold otherwise would constitute a radical departure
Counsel,
from the precedents of this court. Yes, Your Honor.
Did the plaintiff's claims arise before or after the dissolution?
The plaintiff sued for liabilities incurred prior to the annulment of their authority, and it's an important distinction that Nestle was in fact never dissolved.
Prior to the filing, right? That's the key. Prior to the filing of the certificate or order or decree of dissolution.
Well, there was never a decree of dissolution. There was a certificate of annulment of Neslemer's authority to conduct business in New York. And it's actually a critical distinction and a reason that Supreme Court incorrectly applied Section 1311
but the
of the Business Corporation Law.
certificate of dissolution was filed when? Prior to
a certificate. A certificate of dissolution has never been filed because Neslemer is a Delaware corporation. The New York State filed a certificate of annulment of Neslemer's authority to conduct business in New York in 1995.
So that's what BCL 306, I'm sorry. Salian, you wanted to speak? You have.
But it was also, annulled in Delaware too, right?
That's incorrect, Your Honor. Neslemer, its authority to do business was never annulled, dissolved, or canceled in the state of Delaware.
Voided, right? It's not it was voided in Delaware. It's not, the Delaware Secretary of State took action against the corporation in Delaware, correct?
Yeah, in March 1st of 1991. Am I misreading? Am I misreading the record at 323, 654, and 358 incorrectly?
You're not reading it incorrectly, Your Honor. But our position in this case is that being void is not the equivalent of being dissolved.
Well, the Delaware courts seem to think it is. I mean, there are several Delaware opinions that state that. So
counsel,
that's not right.
What do you believe your status was in 1991 when the Delaware court found it to be void, or in 1995? What do you believe the status of your corporation to be?
Delaware existed then, and it has always existed. And the most critical document in this case is at page 356 of the Luca record. That's a certification from Delaware Secretary of State. And what that states is that Delaware has always had a legal existence and has never been canceled or dissolved. Being void is not good enough to trigger BCL 1311, nor is you have to be not only dissolved, you also have to be authorized at the time. And Neslemer was not authorized at the time that the plaintiff attempted service. So the statute doesn't apply for those two reasons. But there's a third important reason that turns on the same Delaware certificate. There's a portion of the statute that Supreme Court omitted from its decision. And that portion requires more than that a company being dissolved.
Counsel, what do you think the import of BCL section 1311 is?
The purpose of it
doesn't that apply to authorized foreign corporations that are dissolved or whose authority or existence is otherwise terminated or canceled, and the filing of the certificate attesting? I'm reading from the section.
Your Honor, if all three of those things had happened, the statute would apply. But none of those things happened here. First, the third word of the statute requires that the foreign corporation be authorized at the time of dissolution. Neslemer was not authorized. Second, it requires that there be a dissolution, not avoidance. Neslemer has never been dissolved. Page 356 of the record is a certificate from Delaware Secretary of State that says, I quote, that Neslemer has, quote, a legal corporate existence not having been canceled so far as the records of this office show. And it then states every certificate ever filed in Delaware on Neslemer's behalf. Third, in order for BCL 306 service to be triggered, the Delaware Secretary of State has to send a certificate attesting to the dissolution or cancellation of authority to New York Secretary of State. And that never happened here. In fact, the Delaware certificate I just read to you establishes the opposite. So BCL 306 cannot apply. BCL 307 had to apply. And that's what all the precedents of the Court of Appeals and this court and the other appellate departments provide. And I would also direct the court's attention to the third department's recent decision in the Garrow versus Pittsburgh Logistic Corporation case. And that was issued after these cases were briefed. And the third department similarly held that foreign corporations who are not authorized must be served under BCL 307.
Thank you, Mr. Denuncio.
Thank you.
Let me hear from your opponent.
Good afternoon, and may it please the court. My name is Renner Walker, and I represent the respondents in these cases, the Luca and Germain families. This case, as my opposing counsel sort of set forth, is about how you serve an authorized foreign corporation who was headquartered in New York, by the way, after that corporation's authority is, quote unquote, voided in its jurisdiction of incorporation. BCL 1311 applies very broadly. It has open-ended and inclusive language that is designed to capture a wide variety of conduct, sort of jargon, I guess I would call it, as well as substantive legal doctrines in not only 49 other states, but across the globe. It is New York is a hub of global business, and corporations apply for authorization to do business here from like I said, from Iowa, from California, from New Jersey, from Delaware, but also from France and Brazil and other places. The jargon, the terminology is going to be different, and that's why the substance of what happened to Neslemer is what's more important than is the term void in BCL 1311. And I'd like to, before going on, I'd like to just address just a couple of just to correct the record and make sure that a few of the undisputed facts are clear for the court. So at the time, the plaintiffs were exposed, and the plaintiffs' decedents in this case, they were exposed in New York prior to the voidance in 1991, and they were exposed prior to the annulment of authority in 1995. Eddie Germain was exposed his wife via take-home exposure dating back to 1979. Vincenzo Luca had been using.
So this was tortious activity committed within the state before the certificate was voided.
Precisely, Your Honor.
So okay.
And so on the day in March 1991, when Delaware voided Ms. Slemmer's charter and annulled when it voided its legal authority under Section 511 or 510, excuse me, of Delaware law, the Slemmer was still authorized to do business in New York at that time. And so this is a classic situation of why BCL 1311 applies. It's that there's a pre-existing tort liability, and a corporation should not be free to break laws in two states, to commit a tortious act in New York and then to cease following up on its requirements under Delaware law, and then obtain the reward, frankly, of a tougher and more strictly construed form of service, as opposed to the liberally construed and familiar form of service under BCL 306 subsection B, that it agreed to in the first place. That's what BCL 1311 really is. It is an enforcement of a continuation of that original designation, and that the designation is made in BCL 1304 sub A6. It's a requirement of applying to do business in New York. And it's important here because every situation where an authorized foreign corporation ceases to be authorized for one reason or another. BCL 1311 speaks in terms of dissolution or the cancellation of authority, as well as mergers and other types of things. But under 1310, for example, BCL 1310, a company can voluntarily surrender its authority. But 1310 sub A6 provides that, again, the Secretary of State shall continue as the agent for service of process. And so it's a very broad, and it applies, and I think what my opposing counsel is trying to get at is that perhaps there was an annulment under the tax law without a delivery of the certificate from the Delaware Secretary of State. But first off, this is the first time my opposing counsel's ever said that. It's a little late in the game. That the obvious inference in any event is that the voidance happened in 1991. The annulment happened in 1995. The Delaware Secretary of State followed through on its obligation. But even if it didn't,
so the tortious acts occur before voidance or before any of these actions with respect to the corporation take place, you should not be able to avoid liability. Precisely. So you shouldn't be allowed to commit torts in New York and then dissolve or otherwise do something with respect to the nature of the corporation or the status of the corporation and avoid liability.
Precisely, Your Honor.
Okay.
And I do want to correct the record on one thing. So my opposing counsel said the most important document in this case, the most important page of the record is page 356 of the Luca record. And by the way, this is not in the Germain record, and here's why. Because if you scroll down, if you're looking at that piece of paper and you get down, there is out of the many documents that my opposing counsel said are included on this printout from the Delaware Secretary of State, one is a certificate of revival filed on April 20th, 2020. And what happened was my opposing counsel lost the motion in Germain and then quickly went to the Secretary of State in Delaware and revived the Slemmer corporate charter and then said, okay, well, it was never dissolved. But corporations don't need to have a certificate of revival if they didn't lose their authority or existence in some way. And I would like to just point out in response to Justice Scarpulla's question that Delaware does treat voided corporations quite a bit like dissolved corporations. It is, as our brief admits, it is a sort of, I think, developing. There is some disagreement in the federal court, but this court doesn't need to weigh into that because BCL 1311 is broader than just.
We don't need to listen to federal courts anyway. So at least not with respect to state law.
Exactly. It's a question of, and BCL 1311 is a question of New York law. So whatever the Delaware Secretary of State would say about avoidance versus a dissolution, or certainly a federal court for that matter, does not bear on the legal import of BCL 1311. And I think it's important to note that every section that deals with this, whether it's BCL 1303, where it's an attorney general nullifying a corporation's authority in New York, whether it's 1310 and a surrender, 1311, if it's this sort of status thing, it always says, as you said.
We got it. We got it, Mr. Walker. Thank you so much.
Thank you so much.
Let me hear from Mr. Denuncio. You have a couple of minutes.
Thank you, Your Honor. First, hold that a tortious act to a loss of authorization would be sufficient to allow service under BCL 306. Explicitly, it would rule the Flick versus Stewart Warner case, because in the Flick case, it also involved an instance where the tortious conduct took place when the corporation was no longer authorized in the state. This court's decision in Issing versus Madison Square Garden also held BCL 307 to apply because the corporation was unauthorized. And I'll quote from Flick. It says that the differences between whether to apply BCL 306 or 307, they quote, depend upon whether the corporation is or is not authorized to do business in the state. And it's important to note that that's the present tense. That is not the past tense. Also important to note that this is the Court of Appeals, and they're identifying that when the company is not authorized, not was previously authorized, BCL 307 can only be applied to unauthorized foreign corporations. Now, I'd also like to address Delaware law. It is absolutely not Delaware law to treat void and dissolved corporations as akin to one another. In fact, a void corporation by statute cannot dissolve until it pays its franchise taxes. So there's not an analog in Delaware law in terms of how those companies are treated. Finally, I would like to address the fact that the parties had a stipulation that the plaintiffs would effect service pursuant to BCL 307. And their argument that the BCL 306 service is valid is pure revisionism. And they induced Neslemer to rely on that stipulation and not participate in the litigation until after summary judgment was decided. That stipulation was disregarded without any good reason.
Okay. Thank you, Mr. Denuncio. Thank you both. Great arguments.
Thank you.
Thank you, Your Honor.
Okay, correction officers versus City of New York.
Good afternoon, Your Honor. May it please the court. Kevin Osowski on behalf of the City of New York. COBA's complaint asked the court to make granular policy decisions about staffing, training, and equipment that have been designated to DOC's discretionary authority. But even those political questions aside, COBA fails to allege a basis for a suit under PESHA and is unable to assert a claim under the WVPL. And accordingly, Supreme Court should have dismissed COBA's case. With respect to the political question here, COBA does not dispute that DOC has been designated the authority to oversee inmates in prisons and their conditions, but rather argues that it's not seeking to order fiscal priorities or engage in general oversight over the agency. But a look at COBA's complaint reveals otherwise. It shows that what COBA is asking for is significant involvement.
How is what plaintiffs are asking us to consider here different than in the recent decisions in Center, in which I participated?
So there are a couple issues in which those cases are different. First, here, the COBA is asserting a private right of action, where I believe those cases involved enforcement actions by the Department of Labor. And I think that issue alone shows that this is something that has been designated to the executive to administer and determine, rather than something that employees should be able to raise their own suit and challenge these kind of determinations. And what COBA is asking for here is injunctive relief that really does require the court's granular decision-making or granular investment in agency decision making, right? They're asking for the court to determine which officers get what training and which equipment. This is significantly different from the case that you alluded to, Your
This
Honor.
is what you claim. I mean, they're basically asking us for staffing, training, and equipment, generally within the ambit of the commissioner or those in authority to execute policy within the corrections department.
That's correct. That our political question argument is basically that this is something that has been designated to the Department of Corrections, and if COBA has an issue with the way that the Corrections Department is addressing this, they need to take it through the Labor Department, and the Labor Department can assist in resolving that issue.
Now, obviously, Supreme Court found that the plaintiffs had a private right of action under PESHA because DOC has an obligation, I think it's stated, to provide the workers with a workplace free of recognized hazards. So what is your response to that?
Yes, Your Honor. So we argue that the Supreme Court erred there in finding that the general duty clause of PESHA applies here. COBA does not dispute that they are law enforcement officers, and the Court of Appeals has clearly stated that PESHA does not apply to the risks that are inherent in law enforcement. And the same risks that are present here are the ones that the Court of Appeals addressed in Williams and alluded to again in Gammons. It's the kind of risks that involve uniquely sensitive judgment calls about how much security should be provided to prisoners and under what circumstances prisoners should be detained or handled. And I think if the court looks to the way that that the Court of Appeals in Williams discussed Balsamo, it's instructive as to how the Court of Appeals considers risk in the context of PESHA. And that carve out for risks unique to law enforcement work. The Court of Appeals in Williams looked at whether the risk was unique to law enforcement. And in here, this type of risk, the risk of assault by an inmate, is one that is unique to law enforcement. It's not like the other cases that COBA is citing, where the same risk might apply to any public employee in a different context. And we're talking about things like, vehicles that are not properly maintained, or a dangerous surface that hasn't been appropriately padded, or training that isn't provided without that doesn't include the proper safety provisions. Those kind of things do fall under the general duty requirement of PESHA. But here we're talking about the assault from inmates, and that is a risk that's inherent to law enforcement, and it is exempt from PESHA. In addition,
it's not so much that it's not inherent. The issue is whether or not you're taking the proper procedures to protect the officers from these risks. I mean, I think it's clear that, this is something that may occur in a facility, but the question is whether you're taking the proper procedures in terms of providing the officers with the various materials, the spit masks and et cetera, that they would need in order to deal with these issues.
And DOC's obligation to do that is enforced by the Department of Labor through the WVPL.
No, but that's not what, the Court of Appeals, why isn't that safeguarding the rights that are provided to officers to be free of assault by inmates? Why isn't that something that the Court of Appeals has said is within the province of the judicial branch to define?
So it is something that the Court of Appeals has said is not within the general duty requirement of PESHA, and that's what COBA is asserting here. That type of risk is a risk that is inherent to the law enforcement activities.
So you're saying that those decisions are basically judgments, discretion, allocations of resources, and priority, and those are restricted to policymakers, not the judiciary.
That's correct. In the same way that the decision in Williams involved similar decision making about how the safety should be.
Counsel, a question. So here, COBA sent a letter to the Department of Labor in May of 2016 and described some pretty serious situations confronted by corrections officers and requested immediate intervention. Nothing happened. So 6 days later, COBA requested injunctive relief and then moved into the court system. If you're saying that there's no private right of action and that they don't belong before us here, what was their recourse? What was COBA's recourse when there was no response to a letter requesting urgent and immediate intervention?
Yes. So COBA's the proper course that COBA should have taken is to approach the the labor commissioner under the grievance provisions of the WVPL, and that provides the process by which the employee approaches the employer, attempts to work out a resolution. If there's not a resolution, the employee can make the report to the labor commissioner, who can investigate and may enforce. They also, frankly, had the opportunity of attempting to enforce enforcement from the Department of Labor through an Article 78, but they have not taken that approach here. Instead, they're asserting a private right of action initially in their complaint under PESHA, and in their brief and response on appeal are asserting that there's some sort of combined claim, or that they have an implied right of action under the WVPL, which there's simply no basis for them to do so.
Thank you, Mr. Ostowski. Much appreciated. Let me hear from respondents.
Yes, may it please the court. Good afternoon, justices. On behalf of COBA Correction Officers Benevolent Association, John Burns. Your Honors, it's simple. DOC is failing to provide, as Justice Weber said, a place for correction officers that is free from recognized hazards that are causing or likely to cause death or serious physical injury. And that's Labor Law 20, Section 27. We're looking here at a very limited relief. It's not injunctive relief. It's relief that there would be some extra training provided to correction officers who are dealing with people that are in the punitive correction unit.
Mr. Burns, how is it that doesn't exceed or go beyond what the Court of Appeals has said is proper within the judiciary to address? I mean, the issue that for example, we consider that in center in the context of interpreting a city human rights law, which I grant is different, but we also the Court of Appeals dealt with it in Williams and other cases.
Yes, I think that if we had a developed record from below, I might be able to answer that a little bit better, but I don't think this is a political question at this point, and I don't think it is a matter of management or operations or a policy matter. What we need to do here, and as the court below said, is to see whether DOC is upholding its minimal statutory obligations that it owes to the correction office that work for them. These are officers that are assaulted. They can't do their job like we are here on Zoom. They're face to face with dangerous people on a daily basis. And
so, Mr. Burns, so your argument is just like in Center for Rehabilitation, we were upholding or defining the contour of the city human rights law. Here, we would be defining the rights and safeguards that are given to you by Section 27.
Allowing us to develop a record below to make sure that there's a better understanding as well. This is a 36-year-old statute that the city relies on, and they shouldn't be relying on the New York State Inspector's case and then the McKechnie case that follows it. We should be allowed to advance the labor law to show how this applies. If it's a grievance, the court below can say, hey, this is a grievance. It doesn't belong here. But here, preemptively, the city makes a motion to dismiss the application regarding the correction officers. As I said, regularly they have feces thrown at them, urine thrown at them. There's fires that are set. And they're dealing with dangerous people. And if I may, it's not in the record, and if I could just indulge the court, looking at the mayor's management report, in 2016, the monthly rate of assaults by staff, by inmates, was 7.9 per 1,000 employees. In 2020, the monthly rate had doubled to 15.8%. Now, what's more disturbing is serious injuries. In 2016, it was 0.2 per 1,000 employees. In 2020, it tripled to 0.65. But what's startling is that the inmate population in 2020 had been reduced by 40% over what it was in 2016. So it's not getting better; it's getting worse for the men and women that are at dealing with these inmates. And I think,
Mr. Burns, the dangers that are inherent in a correction officer's job are truly I don't know what word to use except awesome. They're very serious. And my question to you is the same question as I put to your adversary. Given the fact that the WPPL exists, what was COBA's remedy once there was no response to the letter to the department, to the Commissioner of Labor?
I think they could have taken and looked for injunctive relief on a TRO. They didn't. They filed this lawsuit.
Did they have to do it? Did they have to do an Article 78? Is my question.
I don't think. I mean, having just come into the case and not being that up on it, I would ask your indulgence. I don't think they needed to do a 78. They're taking the course here that they have, and I think what really has happened here is that the city's position is that we're not going to get an opportunity to be heard. They want to use the New York State inspectors. They want to say it's a political matter, a policy matter, a management issue, and what it really is minimal.
Aren't you asking in your complaint for a specific type of training? Not just train us better, not just follow the law, but you are saying we want mitts, we want gloves, we want the ESU training, that ESU people, and until you give us that training, only ESU people, that's what you're asking for. That's your relief. Now you're saying to us, make that determination that this particular type of training, as in contrast to any other type of training that one might get in this situation, that this is the one that we're going to order. And you're telling us that unless, and we are to tell corrections, unless you get that type of training, you shouldn't be in the prison with prisoners who have disciplinary problems. I can't imagine something that's more of a policy decision than ordering something like that.
I would imagine, looking at the complaint, it seems that what had been requested was that as an analogy of what type of training is out there. And I would submit that if we had enough, but if we had enough. I can't
imagine anything more policy oriented than us selecting what kind of training corrections officers would get.
Well, I think if we were given the opportunity to develop the record below, we might have an opportunity to look at the current state of affairs. Again, this is 2016. There's been a federal monitor put in place. There's been a number of different changes. And I do think that if we had an opportunity to develop this, there might be a better, the parties might have an opportunity to be a little bit more flexible in finding
Thank you, Mr. Burns. Thank you, Mr. Burns. Much appreciated. Let me hear back from the city.
Good afternoon. As I believe Mr. Burns acknowledged, the risk here that correction officers face is certainly significant. We don't mean to minimize that, but it is one that is inherent in the job and one that the record demonstrates is inherent in the job description.
I mean, I agree with you, it's inherent in the job, but it doesn't relieve you of the responsibilities to protect them. So the question that we have at this point, I understand the issue of, listen, this court, nor any other court, wants to get into the realm of the commissioner who's responsible, those responsible for managing the day-to-day functions of an entity like this. We certainly don't have the expertise. But what I hear Mr. Burns saying is, this was a lawsuit filed in 2016. Things have gotten a lot worse. In fact, he points to 3 times the number of incidents when the population has been going down. Should we allow for some discovery for them to redefine what remedy it is that they're seeking, particularly when they're not getting a response from you to the letter that they sent to the Department of Labor?
So, Your Honor, the discovery here would not make a difference in terms of the end result, which is a request that the court involve itself in this kind of granular decision making. If the
no, but you're
What
right.
if
You're right.
What if the discovery? I'm sorry. What if the discovery did in fact? What if the discovery did in fact reveal that the precautions or the training that you now are administering to the corrections officers are inadequate to deal with the issues? What if that were what the discovery uncovered, which is, I believe, what Mr. Burns is arguing for? What about under those circumstances?
So 2 points in response there. First, under the department's obligation under the workplace violence prevention law would require the department, or might require the department, to revise its workplace violence prevention policy so that it meets the Department of Labor's standards. And so that kind of evidence might show that it's not compliant with the workplace violence prevention law, but COBA doesn't have the ability to enforce the workplace violence prevention law under the law.
I have an existential question, which is, how does one resolve the issue that there's been no response to this letter from May 2016?
Yes.
What recourse does COBA have? What recourse do these corrections officers have if they comply with the WVPL requirement that they write a letter and then there's nothing in response? What is their remedy? You're saying, what
their issue then is that they haven't received a decision, or they have received a final determination from the Department of Labor, and their issue would be with the Department of Labor, which the WVPL charges with enforcement.
Mr. Osowski, would that be a decision that they would issue on default if you haven't responded? I mean, part of the problem, for me, the question is not existential as it is for Justice Gonzalez. But my concern is, if you're saying their remedy, if you're saying we are not allowed to engage in this deciding political questions or in basically micromanaging the Department of Corrections, and the only remedy that the COBA has is with respect to Labor Law Section 27, which you refuse to engage in, you're not even responding to it. What do we do?
Well, so I think it's an important distinction here that it is not the city that has not responded to that. And to my knowledge, the city and COBA are engaged in active discussions. They frequently engage in discussions about safety and about the changes that the department may need to make. But COBA's complaint about the non-response to the letter is really with the Department of Labor, and that's the avenue for enforcement that they should be seeking here.
Okay. Thank you, Mr.
Thank you, Your Honor.
Thank you both.
Thank you, Your Honor.
Benitez versus City of New York.
Yes, may it please the court, Nicholas Yanuzzi for the appellant plaintiff. Essentially, we're here today because the lower court erred in granting summary judgment in the face of many questions of fact, none of which they addressed.
Yeah, Mr. Yanuzzi, I will, we have limited time, so I don't want you to take, to not argue some of the requirements that I know exist within the city human rights law to reasonably accommodate your client. That was something that you raised in your brief and you spent a great deal of time. And I know that the city's response is that they basically, the threshold determination is that the sergeant himself needed to ask for the accommodation rather than a recitation of current law, which has been in place in September of 1991, when the law department itself helped draft that law. And that is a law that affirmatively requires the police department to consider disabilities that they know about or should know about in dealing with Sergeant Benitez. Do you want to address that?
Sure, Your Honor. Yes, essentially, as you say, the human rights laws, state and city which being a little more expansive, it creates a affirmative duty on the part of the city and the NYPD once they realize that, or once they know that there is an accommodation needed, a situation that needs accommodation. And in this case, they knew of Sergeant Benitez's condition from the beginning, and they really did nothing. This policy of assess, not treat, they assessed him, said, yes, he should be on restricted duty, and then they sent his name on its way. No dialogue.
Is it disputed that really the only evaluation or the purpose of any evaluation done by the police department is really to determine fitness of the officer? And once they determine fitness, they feel that they're not obligated to engage in the dialogue, for example, that's contained within the Local Law 59 that was just enacted in 2018 to basically highlight the importance of what was enacted back in 1991.
Yes, Your Honor. Essentially, yes. That is how they feel. They feel that their entire duty is to make the assessment, and then once they've done that, they're absolved of any sort of duty past that, and that's a policy of essentially avoidance. They're keeping themselves at arm's distance so they avoid any sort of liability.
I mean, do you know? I read their briefs, and I mean, what I don't hear them say is that they somehow not bound or obligated to comply with the Administrative Code Section 8107-15A, which talks about what the dialogue needs to be, what the interactive process needs to be, what their obligations are to accommodate non-disability. None of those things took place here. Am I correct?
No, you are correct, Your Honor. Nothing took place here. Past the assessment, that was the end of it. He was assessed in the end of December, and then he was assigned to a job, and the psychological unit did not speak to him again. Part of this policy, it seems to me, after having read about all these the policies and the cases and all such, the City of New York and Police Department are happy with this case Saigon, which they feel protects them from situations like the one in this case where a police officer kills himself. They feel that they have no duty there because they have this case. And similar to what the lower court did, they saw suicide, they saw police officer, they just assumed that it was an exact fit. And because of that, the NYPD doesn't engage. They don't really have a policy for mental health. They have a policy for physical injuries.
Yeah, but see, to me, that seems to be a separate discussion with respect to duty, right? Does the police department, I think Segan and a lot of, that's a first department decision going back to 1991. I know that basically the state of the law is that they have no duty unless the plaintiff in this case is either under custody of the police department, and very specific circumstances under which they will have a duty, none which apply here, which is why I didn't want to spend too much time whether the department owes them a duty under those statutes, but rather whether they owe him a duty pursuant to the city human rights law.
Well, respectfully, I would disagree with Your Honor insofar as, well, first I would say that I think Saigon in general is inapplicable to the instant matter. The fact patterns are while I understand the shallow comparison, the fact patterns are such difference that to use Saigon to grant summary judgment is just can give no countenance. But
Counsel,
essentially,
this is Judge Scarpello. May I interrupt you for just a second? Did you plead a claim in your complaint for discrimination under the city human rights law?
no, Your Honor, we did not do it at the time.
So there's no evidence in the record about anything about whether or not he actually what the city did or didn't do, because you didn't plead that. You pled wrongful death, right?
We pled negligence.
And only wrongful death.
No, well, we pled negligence and wrongful death.
Negligence and wrongful death. Nothing about human rights violations. So the city didn't answer or put in anything, and you didn't put in anything because you didn't plead those claims, right?
Well, essentially, so I'm
just asking you, did you plead them?
No, Your Honor, I did not plead for a discrimination claim, but the reason
you used a rubric of negligence in order to address the issue of the human rights law. Am I right?
Correct. The human rights law and the labor law, they both create the affirmative duty. That duty, we claim, has now been breached, and
but you only raise it, counsel. Part of the problem is that, I mean, there's a private right of action under the city human rights law, which you didn't use, as Justice Capula put in. But you spend half of your brief, if not more, dealing with the department's obligation to reasonably accommodate your client, which I understand if you had pled a violation of the administrative code, namely the city human rights law. So how do you reconcile that?
Essentially, Your Honor, I would first address that if the court believes that my pleadings are inartfully drawn, I would just remind for summary judgment that the plaintiff should be given all consideration and so on. But I would just say that one of the reasons why discrimination was not pled originally was because we have a dead police officer, and it encompasses that. I mean, the discrimination seems to be the lesser. It should probably have also been, but it's the wrongful death and the negligence is the real thrust of this, because the police officer's dead, not just out of a job.
But you understand that, in the context of Sigan, in the context of the applicable law to a wrongful death action, the duty on the part of an employer is different than, for example, in the context of a city human rights law claim. I mean, let me put it this way: it's hard to hold an employer who has no custody of an employee or is in charge of the conduct of the employee, hold that employer responsible for any action like suicide or other actions committed by those employees. It is only the city human rights law that talks about what should have happened to prevent the suicide from taking place, namely the reasonable accommodation and all of the things that we've been talking about.
Well, Your Honor, to discuss Sigan just slightly more, I believe that we're dealing with a case that the bulk of the fact pattern took place during the 1980s and was decided, I believe, in 91 or 92. We're talking about mental health, and it's a field that has developed substantially since the decision in Sigan. That being said, there is also an argument to be made that the second exception in Sigan about the health professional that detected suicidal tendencies and had the control necessary. The police department controls, in the context of this fact pattern, the police department controlled Officer Benitez's schedule, so much so that the intervening factor of the extra training that caused him to work an entire extra shift, which we're claiming,
Yeah. No, Mr. Anussi, you're not going to get any disagreement from me. I mean, I read your brief very thoroughly. In fact, I read many of the reports to which you allude to, including the one that's footnote 2 related to bipolar patients already at a basic risk of suicide, given sleep disturbances that are linked to increased risk for suicidal ideation and suicidal attempt among bipolar patients. So, I mean, the literature is there, but you will have to agree with me that interpreting, creating a duty on the police department under these circumstances will require us to disregard current law, including Sigan. I know you're trying to distinguish it, but you know, I have difficulties with it. It wasn't a question, it was just a statement. I'll give you time in rebuttal. So let me hear from the city.
Thank you.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of the city. With the court's permission, I'd like to make just 2 points, one on Sigan and one about the state and city human rights law claims. In Sigan, this court said that the unforeseen off-duty suicide of any employee is indisputably a tragedy, but it's not a basis to bring a negligence claim against that person's employer. The court held that there's liability to prevent a suicide under the common law only in 2 narrow situations, sounding in control over the individual's actions, which can't be said of someone who is off duty, and the foreseeability that that person will harm himself, which is just not present in this case. I'd like to refer the court's attention to the testimony of the administrator of Sergeant Benitez's estate, his brother. He said that he spoke on a daily basis with Sergeant Benitez. He was not aware of any indication that Sergeant Benitez would harm himself before he took his own life in March of 2015. Sergeant Benitez did not request an accommodation or a transfer for the night.
Well, let me stop you there, because the question is, was he required to request an accommodation given the language of Administrative Code 8-107-15A, which creates an affirmative. I know what you say in your brief, that the threshold determination has to be a request by the employee. But the language of the statute itself is that as long as you know or should have known of the mental of the disability, which in this case, as you know, is very, very broadly defined in the city to any condition that impacts a system of the body. I know that you know because the law department helped us draft it when I was the city human rights commissioner. So I know that we drafted it together, and that affirmative obligation is there. There's no dispute that you know that he was bipolar, and let's agree for the moment. I looked at the record. I didn't see a single request by the sergeant to be accommodated. That's not surprising, given how the macho environment of a quasi-military organization, you know, people don't ask for accommodation for mental disabilities. You know, let's be cognizant of that. So what do you think your obligation is under that statute?
So, Your Honor, I disagree with you about the reading of the statute. It's correct that the department knew he had bipolar condition, but it's not just the knowledge of the disability, it's the knowledge that there's a need for an accommodation. And here, going back to the administrator's testimony, his brother said, I was not aware that he asked anyone in the department or
This is Judge Gonzalez. You're talking about someone who had 3 psychiatric hospitalizations after his fellow officers came to his house and found him in a very bad way. His fellow officers looked out for him, and
Your Honor,
and there was a referral. There was a referral for a psych evaluation, and he ended up being hospitalized, and he's back at work within 6 months. How can you say that there's no knowledge on behalf of the police department that this person needed to have an interactive process to determine what accommodations he needed?
The reason, Your Honor, is it follows that it's important for someone with bipolar condition to get enough sleep and on a consistent basis. It does not follow that someone who works the night shift necessarily is not able to do that. And here, there's just no evidence that the department was aware that he was having issues working nights or having trouble sleeping.
So I mean, I'm not going to impute knowledge of what the available literature is for folks that are disabled and who are who are deprived of sleep, or that their regular order of sleep is disturbed. I mean, much of the literature is cited in plaintiff's briefs. I'm not going to go through that. But my question to you is, do you have any obligation? I mean, you have a psychologist that determined that he was still fit for duty. Nevertheless, you made an evaluation, you took away his gun, you took away his shield. Clearly, you knew he was bipolar. He was referred to a psychiatrist. He was interned for a few weeks, right? Then he came back to work. You feel that there's no obligation on your part to engage a police officer under those circumstances in some dialogue, frankly, a dialogue that was just basically incorporated at the First Department Phillips decision into Local Law 59, which now makes it an unlawful practice not to engage in that dialogue. So clearly city policy is that once you have an employee who you know the condition is in the shape that we described, you basically feel like we can assign them based on your recognized duty. Your duty is like, well, I forget how you say it in your brief. If he's fit for duty, you get to assign him as you deem fit, as you need, not based on the conditions that you have identified, but based on your needs. And I read the human rights law as requiring something a lot more than that, including unless you have an undue hardship of some kind. And I haven't heard in your brief what is the undue hardship that you would have had by engaging him in this interactive process.
Your Honor, two answers. One, we disagree with that reading of the law because it gets some things backwards, because under the estate's reading, an employer, as soon as they know that an employee has a sufficiently serious diagnosis of any mental condition, they have to either assume what they can or can't do or potentially ask invasive questions of them. And that just runs counter to the structure and purpose of the human rights law when it comes to disability, discrimination, and accommodations.
What I was reading to you was the exact language referring to an affirmative obligation to make a reasonable accommodation on your part. And I'm reading you the decision that I wrote in Phillips that was upheld by the Court of Appeals, and now that has been incorporated into Local Law 59 with respect to what the obligations are of an employer. So I'm not talking about what the estate says.
Your Honor, sure. But again, it just was not known to the department that there were any issues with working nights or with his sleeping. And again, as Justice Gonzalez alluded to, this just isn't a claim in the case. I think there are interesting issues to explore.
It's actually Judge Scarfula, and I want to ask you, was there any expert testimony below? Anything about this that you can't work at night? Was there any actual factual testimony or expert testimony about that issue in the record below?
The only evidence was testimony from the NYPD psychologist, Dr. Lamstein Rice, who said that, yes, it's important to get enough sleep, but it doesn't follow that just because you're working nights, you can't do that.
So the plaintiff didn't put in any evidence about this, that citing to all these out-of-court studies talking about sleep. Nothing like that was before the trial court, correct?
There was no expert interpreting the studies that the estate adduced. That's correct, Your Honor.
But it was more than. But it was more than than working overnight nights in the Viper unit. It was also having to go to a program the next day and work through the night and the day. Am I right?
Yes, the estate claims that based on a single 16-hour shift, it was foreseeable to the NYPD that that in combination with a bipolar would cause Sergeant Augusto to harm himself.
I have to say that I know we're looking at an individual case, but in the context of all the police suicides that have taken place, I'm just stunned. I'm just stunned by what you're saying.
I hear what you're saying, Your Honor, but I would just end with 2 points. One is that to the extent that the crux of the estate's complaint is the 16-hour shift, that is nowhere in the notice of claim. It's nowhere in the complaint. I believe it first appeared in the bill of particulars. And the second thing is, I would ask this court to exercise caution when extending the common law duties of employers, because that's the claim we really have here. It would apply to any employer, regardless of their size, regardless of the sector of the economy they work in, regardless of whether they're public and private. And the kind of line drawing.
I understand that completely, Mr. DeSilvio, but we're not talking about common law responsibilities. Your best argument is that this wasn't properly pled, but yes. What the obligations are of the police department, what the obligations of the police department are pursuant to the city human rights law, including local law 59, which I'm sure you were part of the drafting of 2018, it imposes a specifically obligation on the part of the department to engage with its officers, particularly one that has already been diagnosed as bipolar or having mental illness and was determined to be fit for duty by your own psychologist. That is a policy that needs to be evaluated, regardless of how we decide this case. And the reason that that needs to happen is because the legislature of the city of New York, that's the policy choice that they made. That's not a policy choice that I made. I just read the statute, and with respect to affirmative obligations on the part of city agencies, my recommendation, just like you asked me to be cautious not to impose additional duties, I impose a duty on your part to read the law as it is currently delineated both in the city human rights law and in the local law 59. And with that, thank you so much, Mr. DeSilvio.
Thank you.
Mr. Iannuzzi?
Yes, Your Honor. One of the main things I want to touch on is this policy. My counsel was mentioning that that Officer Benitez didn't say anything, they didn't hear anything, and as far as they know, there was no problems. But part of that is because of this negligent policy, they didn't talk to him for 3 months. The psychologist didn't even know where he was assigned. She knew nothing about it. And talking about the reasonable...
But Mr. Iannuzzi, and I understand that completely, and I empathize. The problem is that you're couching it in terms of a negligent policy, but that's not how the law, including case law, seems to refer to the issue. The statute, the city human rights law statute, doesn't call it negligence. In fact, discrimination is an assault to someone's dignity, right? So they characterize it differently, and they define the obligations of the NYPD differently than, for example, a common law negligence action or even a violation of the statutes that you cited.
Well, Your Honor, I mean, I understand what Your Honor is saying, of course, but I would just remind or re-mention talking about the labor law as well, environment free of hazards, recognized hazards, one of which is hazards such as mental health. It's not one that has much case law to deal with it, because this is, kind of the new frontier of litigation is people have not done enough about mental health. The police department, more than anyone, it seems, because they're consciously avoiding the policy, making a policy about mental health.
And that is the white elephant in the room, Mr. Iannuzzi. It's not just governmental employers that are doing that. Every employer. I mean, it seems that we have, particularly in the context of a quasi military organization like the police department, it's hard to claim or request an accommodation based on a mental disability. There's a stigma that still, unfortunately, in today's societies, occurs, particularly among police officers. That is an issue that we need to deal with in society. The question here is a little more narrow for this court, namely to decide the issues as they were charted both by you and the NYPD through Mr. DeSilvio. So I know that we've spent a lot of time on this case. Thank you both very much for the arguments.
Thank you, Your Honor.
Thank you. Johnson versus Asbury.
Good afternoon. May it please the court. My name is Patrick McGlashan. Can you hear me? Can you see me?
Yes, we can.
Okay. I am the attorney for the appellants on this appeal. This court should reverse the order of the court below because the complaint, even if all its allegations are accepted as true, does not state a claim for fraud or illegal conduct. BCL section 623K provides that a member has a right to bring an action on the grounds of corporate action being illegal or unlawful or fraudulent as to her, and we don't have that here. As to illegality, section 417 of the limited liability law requires an operating agreement relating to the business affairs. There was an operating agreement in this case. And there's no dispute that the operating agreement was annexed to the complaint.
But the question is, Mr. McGlashan, that whether your client was acting in good faith, right, in the company's best interest.
Well,
how do we determine that in the context of a dismissal motion?
Well, you look at what the complaint says. The complaint says that right after the company was formed in 2011, Ms. Ashbury started looting the company. The complaint also attaches a certification application, which was signed in 2013, meaning two years later. They enter into the certification to certify the company as a minority woman in business enterprise. That was based on Ms. Ashbury being a Black woman. And under that certification, Ms. Ashbury retained 51% of the ownership to Ms. Johnson's 49%. Now, from there, the business operated, according to the complaint, up to a point where Ms. Johnson alleges that she was tired of the habitual looting and offered to buy out Ms. Ashbury's interests. Now, at that point, Ms. Ashbury rejected the offer. The business continued to operate. It doesn't say what happened at the point where Ms. Ashbury removed Ms. Johnson from the management of the company and subsequently consummated a merger, but there was enough information to show that Ms. Johnson did not want to be in the company anymore. There was enough information to show that Ms. Johnson...
But she disputes that, doesn't she?
No, that's her claim. Her claim is that she wanted to buy out Ms. She didn't want to be in the partnership anymore.
This is Ms. Go ahead. I'm sorry.
Right. Ms. Johnson said she didn't want to be in the partnership anymore with Ms. Ashbury because of Ms. Ashbury's looting and embezzling. What Ms. Ashbury did by revoking the operating agreement and consummating the merger was to effectuate the result that Ms. Johnson wanted.
Counsel, this is Judge Scarpullo. One, would you not agree with me that stealing from one partner, stealing from the other is classic breach of fiduciary duty allegations? I can't imagine that you wouldn't agree that that's true. And two, the complaint alleges that the majority shareholder or LLC member, in breach of her fiduciary duties and as not in the best interest of the corporation, not as a good business decision, shut out, literally took away all the shares of the minority shareholder, and then again breached her fiduciary duty by offering her less than 10% of what her shares were worth. That's a classic straight up, I mean, I myself have seen complaints like that 100 times. That's okay. A classic breach of the LLC agreement claim and breach of fiduciary duty claim. This is a pre-answer motion to dismiss, right?
Again, yes. And again, We're here because of the BCL section 623, section K, which arises in the context of a merger. So her obligation was to show that the merger itself was illegal. All of the claims.
That's not her only claim, counsel, and that's not her only ability. That's not the only thing she can argue.
She's
Number
claiming.
one, number two, this is an LLC, right? That's not her only claim, and that's not the only law that's applicable.
Well, the only case that was cited in the by the court below is SBE Wall LLC 44 Wall, and in that case, the plaintiffs were allowed to bring a plenary action, as is happening here in the context of a merger, because of representations that were made by the defendants prior to the merger. That did not happen here. There is no affirmative representation by Ms. Ashbury on which Ms. Johnson relied to her detriment. With respect,
if I may, was there a right of first refusal offered to the plaintiff? Isn't that one of the issues before the court?
The issue with that is the complaint alleges that the old operating agreement was improperly amended, but it wasn't. It was revoked.
But that's what you say. But this is a 3211 motion. We have to accept the plaintiff's allegations as true.
Right. So the allegation itself says there's a new operating agreement and there's no indication of what happened, except it doesn't say anything about the old operating agreement.
Well,
under that circumstances,
she says that basically, what was it? She alleged material omissions failing to inform plaintiff of her plan to usurp sole control of JNA.
And there you're talking about notice. The statute for effectuating a merger does not require notice. The statute for amending or revoking an operating agreement does not require notice. And if we're saying that you can operate based on the terms of the operating agreement, the old operating agreement under section 4.1 permitted Ms. Ashbury, with her majority interest, to have only one manager. She did that. Under section 4.3 of the old operating agreement, she could effectuate a new operating agreement, which is what she did. So the complaint is saying,
what is the remedy that Ms. Johnson has in this case?
An appraisal action.
You cited to BCL 623, but doesn't that section allow dissenting shareholders, to basically to seek equitable relief, like in this case?
Right. That's the point that we're making here, that she has to establish that the merger itself is illegal as to her. She hasn't pointed to anything in the operating agreement.
But she has made all allegations about what your client did and didn't do that proves fraud, and that at least on their face establishes the causes of action that, for injunctive relief and for fraud. We're not here to examine the merits of those claims. We are only here to examine whether she has pled.
Well, in the context, I understand, I agree, and that's in the context of a merger. The BCL section that I'm referring to, the leading to that section states that the shareholder can no longer raise any claims that she may have by virtue of her membership interest, except if she can show that the corporate action, and in this case, the merger, was illegal as to her or fraudulent as to her. And the case SBE 44 Wall is the one case in the entire record that dealt with this issue. In that case, the plaintiffs were suing the defendants. In order to complete the litigation or to end the litigation, they entered into a settlement agreement. The defendants then consummated a merger. Under that merger, they did not give the plaintiff the merger documents. They also gave the plaintiffs zero interest for their interest. The court in that case held that the plaintiff had met their burden and could bring a plenary action in the context of a merger. We do not have that here. She is bringing actions by virtue of her share membership and grafting it on to basically try to invent a situation that she can use BCL 623 to move forward on.
Thank you, Mr. McGlashan. Let me hear from your opponent. You have a couple of minutes in rebuttal.
Good afternoon. May it please the court. My name is Heather Foyer on behalf of respondent Melissa Johnson. Your honors have really hit the nail on the head here. We're here on a motion to dismiss. This is not a summary judgment motion. This is not a closing argument. The only issue is really whether the lower court correctly determined, based on the allegations in the complaint, whether the facts assumed to be true assert causes of action. That is precisely what Justice Kennedy did when she denied their motion to dismiss. Appellants cite to the standard on a motion to dismiss, and yet they completely disregard it. They have their singular purpose at this point and throughout their brief and today has been to...
In fact, it seems to me that the defendant's argument ultimately is turning on the contentions that are really raised in the defendant's affidavit. And affidavits usually are not documents that we consider in the context of a dismissal motion.
That is correct, and that is also what Justice Kennedy held below. They moved to dismiss on documentary evidence, among other grounds, and they set forth an affidavit setting forth their own counterstatement of facts, and even criticized our client for not putting in her own affidavit contradicting those facts. It's completely improper on a motion to dismiss and completely irrelevant and not something that should be even considered by this court and was not properly considered by the lower court. Appellants have focused a lot on the fraud claim. They claim that Ms. Johnson did not adequately allege fraud. That is not true. The complaint stated a cause of action for fraud, and the lower court properly found that the allegations in the complaint stated fraud based on material omissions by Asbury as the manager and as the majority member. She withheld over several months what she was doing, which was to overturn, withdraw, amend, whatever she wants, this operating agreement, that she had intention of transferring her full interest, executing a freeze-out merger. These were material omissions, and the court found that these were sufficient to state a cause of action for fraud. And on a motion to dismiss, the only question is whether the allegations in the complaint asserted a colorable legal theory, and they do. The appellants also focus on BCL 623 and how the appraisal proceeding should have been the only proceeding that Ms. Johnson was able to pursue. And that is not correct. And that is also what Justice Kennedy correctly held was not correct. Ms. Johnson followed BCL section 623K, which provides the exception. It permits a dissenting shareholder to commence an appropriate action for equitable relief for fraudulent or unlawful corporate action. Everything that Ms. Asbury did was fraudulent and unlawful. She secretly tried to...
Including, based on your allegations, the merger itself.
Correct. There were, in the original operating agreement, there are transfer provisions, there are buyout provisions, there are provisions specifically meant to avoid what happened here. And Asbury completely disregarded that operating agreement in violation of section 417 of LLC law. She changed the distribution manner of figuring out the distributions among the members, which is improper. The original operating agreement still governs. The merger was invalid, and that is precisely why Ms. Johnson pursued this remedy under 623K.
Okay. Thank you, Ms. Farr.
Thank you very much.
Okay, counsel, you get a minute or two in rebuttal.
Thank you, Your Honor. With respect to the affidavit merely pointed to the complaint itself, which annexed the operating agreement. And with
the affidavit disputes a lot of the allegations in the complaint.
By showing...
That's the whole point that we were making before with respect to whether we consider that affidavit in the first place.
Correct. And so if you're looking at the operating agreement, there are cases that there are plenty of cases that show that where you have an agreement, you can't have an action for fraud. And in this case, we had an operating agreement. We had an operating agreement to.
Well, I thought that section 623, I thought we had settled that 623 permits the dissenting shareholder to pursue equitable relief for fraud or unlawful corporate actions, right?
As
including the merger.
Right. If you can allege how the merger was illegal or fraudulent, there's nothing in the complaint.
Well, she alleges it. Whether you agree with it or whether we agree with it, it's a totally different thing. That's what summary judgment and trials are for.
Right, but the court doesn't have to take it a legal conclusion in the complaint as a fact. There's nothing in the decision below that makes any indication that
when we have a dissenting shareholders basically telling us that in a signed document that there were material omissions failing to inform her of your client's plan to usurp sole control of J&A, that's pretty specific. That's not
exactly.
I don't have to evaluate the merits or whether it's true or not. I'm not the trier of fact.
But the law also requires reliance. And in this case, we have a plaintiff who's claiming that her partner was an embezzler and a looter, and also claiming that she was reliant on that partner. That's an incredible claim. You have to have the reliance and you have to show injury. There is no injury in the decision. There's no injury alleged in the complaint.
Well, she lost 49% of her ownership of the corporation.
Well, by law, under the merger, she has a right to an appraisal action. That's not a loss. That's what the law provides. If the law provides that
she says that you didn't tell her about the merger or what you were intending to do. That's the reliance, right?
That's notice. No, the reliance would be my omission caused her to do something different than she would have otherwise done. We don't know what that other thing.
Your obligations under the agreement to inform her if you're going to usurp her of her rights of her 49% interest. That seems to me.
That would mean the statute requires that you have notice. The statute does not say if you are going to rely on this statute to effectuate a merger, which we did, then you have to let the minority owner know that you're going to do that. Otherwise, you're liable for fraud. That's what they're saying in the complaint.
Thank you. Thank you both. Much appreciated.
Thank you, Your Honor.
Thank you, Your Honor.
Patterson versus NXK.
Good afternoon, Your Honor. Can you hear me?
Yes, I can.
May it please the court, Christopher Della Carpini for the appellant, Ms. Patterson. So Justice Edmeade granted summary judgment because supposedly it was undisputed that this accident did not take place in an Ambutrans van. That when Ms. Patterson was riding home from Mount Sinai on that afternoon and the ambulette she was in stopped short and threw her to the floor, causing her to break her foot, she was not in an Ambutrans van. Supposedly that was undisputed. I'd like to read to you from Ms. Patterson's EBT. This is in the record at page 337. Question, okay, and can you describe the van to me? What color was the van that came to pick you up? Answer, it was the same color it's always been. Question, and what color was that? Answer, dirty on the inside and it's red, white, and blue on the outside. Question, when you say red, white, and blue, is the van white with red and blue? Answer, the van is white and the writing Ambutrans is in red and blue. Question, and that is the van that came to pick you up that day? Answer, yes. If that weren't enough to raise an issue of fact, I'd like to read to you from the testimony of Mr. Reno, Ms. Patterson's caregiver, who was sitting next to her in the ambulette when this accident happened. This is in the record at page 491 to 92. Question, so on that day when you entered the van from the hospital, did you look to see that it said Ambutrans on the van? Answer, yes. Question, and where was Ambutrans written on the van? Answer, on the rear of the van. It was on the side, on the back of the van. It was in big and bold letters, Ambutrans. There's no reason either of those pieces of testimony wouldn't create an issue of fact to preclude summary judgment. Now, Justice Edme pointed out that these two witnesses disagreed on something somewhere in their testimony. There's no disagreement in the transcripts I just read to you. Justice Edme also mentioned that Ms. Patterson had received anesthesia that afternoon. There is absolutely nothing in the record to suggest that anesthesia or anything else impaired Ms. Patterson's ability to perceive, recall, and testify to the events at issue in this case. And even if there were, nobody says Ms. Serino was on anesthesia. Lastly, Justice Edme pointed out that plaintiff did not offer a police report in opposition to summary judgment. Well, Ambutrans didn't offer a police report either. What Ms. Patterson did offer that Ambutrans didn't offer is eyewitness testimony. Lastly, I'd like to point out that not only did Ms. Patterson raise an issue of fact, Ambutrans didn't even prove a prima facie case. They had no witnesses, obviously, so they relied entirely on their documents. And their documents completely corroborate Ms. Serino's version of events. If you look at the email from Ambutrans' dispatcher, which is at pages 209 and 210 of the record, you'll see that his story corroborates Ms. Serino's. The round trip was scheduled. The ride home was canceled at some point that afternoon. It was rescheduled later that afternoon, and then it was canceled a second time, right around the time of the accident, after which Ms. Patterson returned to Mount Sinai in an ambulance. If there are no questions, I'll reserve my time.
How close to the accident was the ride re-canceled the second time?
Minutes. 5:29, 5:30 p.m. That's about when this accident happened. And remember, that document at most goes to make a prima facie case for the defendant. Doesn't do anything to vitiate the testimony.
Yeah, we got it, counsel. Thank you so much. Let me hear from respondents in this case.
Good afternoon, Your Honors. If it may please the court, I'm Advocate Cheney from Donnie.
We cannot hear you.
I'm going to have to lean, so ignore my forehead on the camera.
We cannot hear you.
Is this any better?
No, get closer. I can hear. I heard that a little bit.
All right. How about now?
You're getting closer. You're getting hotter.
That's about as best as I can do. The only thing I can think of is is it better if I'm over here?
Oh yeah, perfect.
There's my issue. Okay. So now you'll get my shoulder. All right. Counsel argues, first of all, that the respondent's documents establish and corroborate plaintiff's version of the accident and whether or not she
keep your voice up, counsel.
Whether or not she was actually on an Ambutrans ambulance. When in fact, plaintiff keeps saying the accident occurred around 5:30. Around 5:30. We don't know what time the accident is because the plaintiff has not corroborated her testimony or Ms. Serino's testimony with any other documented evidence, such as
but why? Who says that she needs to corroborate anything? You have the testimony of Ms. Serino. You have the testimony of the plaintiff. So your obligation as the movement for summary judgment is to prove a prima facie case. What do you have to say with respect to the absence of a police report or documents outside your control that will corroborate or that would establish your prima facie case?
Well, the thing is, Your Honor, the documents that are in our control are unable to be altered, okay? And the audit ensures that, okay? Now, the issue is the plaintiff's testimony and Ms. Serino's testimony are self-serving here. Just as anyone but without any documentation.
They always self-serving, counsel. We have a question from Judge Carpula.
Sure.
I want to say, assuming that your documents do make out your prima facie, let's assume that. Okay. There is not a single case where you can find where two witnesses testified about their personal experience that would not raise an issue of fact that would raise an issue of fact as to business documents. There's no, I mean, this is straight up. They testified to it. You put in your prima facie. Your prima facie is, look, you put in business records. Good for you. But then we have live testimony from two people who are there who challenged them. We can't decide on a summary judgment motion who's correct and who's not.
The issue, Your Honor, is this, okay? These are unsubstantiated, it's unsubstantiated testimony.
No, counsel, let me stop you there.
Testimony. They're under oath, right? It
Right.
is. That's exactly right.
That's all well and good, but think of it as a rear-end car accident or any other car accident where a plaintiff puts in an affidavit, okay, and says, I was hit by your car, and puts only that in.
No, but an affidavit is different than testimony under oath. I mean, listen, good luck with your cross-examination, but there's no way that we can decide as a matter of law that you're correct based not on testimonial evidence on your part, but based on documents that you yourself control. And I understand you said that they cannot be altered, but we'll see what the experts from plaintiff have to say about that.
And I'm sure that the plaintiffs are going to not like being called liars. So the plaintiff is not going to accept being called a liar, right? It's all up to the jury.
I'm not saying she's lying, Your Honor.
Well, that's exactly what you're saying.
No, Your Honor. I mean, maybe she was confused at the time because she used numerous ambulance
and her aide must. You're saying they all must have been confused, and I think what I'm saying to you is that goes to the jury. That's exactly what goes to the jury.
Okay, thank you, counsel. You've run out of time.
All right, thank you.
Let me hear from plaintiffs for a minute.
I'm prepared to stand on our briefs, Your Honor, but I'm happy to answer any questions.
I think we're good. Thank you so much. That's a smart choice.
Thank you, Your Honors. Happy holidays.
Happy holidays.
Thank you. Happy holidays.
Matter of Jewish Press versus NYPD.
Yes, good afternoon, Your Honors. Joseph Aaron here for Appellant the Jewish Press. So essentially the case relates to a FOIL request for documents associated with a motor vehicle accident. The NYPD basically said that the documents are exempt because there's a judicial proceeding. Now, it's black letter law that the NYPD has the burden to prove that any documents requested are exempt. Now, here they have to prove two prongs, that there's a judicial proceeding and that the release of the documents would interfere with the said proceeding. So I'll do the second one first, just because I think it's much simpler. And
I like that because it's very difficult to prove the first one.
Okay.
These are not judicial proceedings. I don't know.
I'm not going to concede, but I'll go to the second.
Got you.
Okay. So in terms of the second one, now all the cases from the Court of Appeals about interference, which respondent cites, Rashid, which is very recent, last year, and Lesher, the Court of Appeals said that what does it mean, interference with a judicial proceeding? It means you would give the charged party an advantage against the prosecution. There's no debate about that. The Court of Appeals said that over and over, but in particularly they say it in Lesher. They really spell it out. Now, the records for the accident, it's interesting because they're open to the public.
So, counsel, this is Judge Gonzalez.
Hi, Judge.
So you're not the party who received the summons. You're not.
Correct.
Your press. Your press.
Yes,
so what is your stake in this?
Okay, that's a good question. It gets to the heart of the matter with the Court of Appeals case in Scott. So Public Officer 66A says that motor vehicle accident reports are public. The Court of Appeals in Scott in 1985 said to an interested party, and according to my reading and the Committee on Open Government's reading, who was given deference by the Public Officers Law in relation to FOIL, says that any member of the public is an interested party in regard to 66A, and therefore anybody who's on the Zoom conference today would be able to get any accident report under 66A. But here's the interesting thing. Let me just finish one thing. Even according to the NYPD, they disagree with the Committee on Open Government's reading in the Court of Appeals of Scott, but even they agree that the cyclist who got hit and the motorist who's being charged at DMV can get those reports under 66A. So it's impossible for the NYPD to show interference because the charged party, the motorist himself, is entitled to those reports. So if the motorist could get those reports, certainly the Jewish press should be entitled to those reports. Because in other words, they have to prove interference. Hey, the party you're prosecuting is entitled to all that information. So how could release to the Jewish press possibly interfere with your proceeding? That's my strongest argument on 66A. And to me, the whole thing is very silly. And because the city, the NYPD, they concede that the motorist is entitled to these reports under 66A. They just say the Jewish press isn't entitled. Okay, Committee on Open Government disagrees with them, and they say the Court of Appeals in Scott says Jewish press is also, but ultimately the point's not even relevant. Okay, so you disagree with how I read Scott in the Court of Appeals case. It doesn't make a difference because you concede the NYPD that the motorist is entitled. So if the motorist is entitled, it can't interfere. It's impossible. And I could just give a way of analogy if it would help the court in a different set of circumstances, how this is much more applicable. Every day newspapers make requests from pending criminal matters. So let's say you want a complaint of a murder. So the NYPD says no because the murderer is on trial. Yeah, but CPL 265 says that the people have to give that to the defendant. So if the defendant already has it, how could you say interference? It's a more common occurrence, but it's the same idea. It's totally nonsensical to say that interference.
Judge Scarpula, are you saying that the district attorney should have to release to all news organizations its reports about a crime, all the video that it gathers, all of its? Is that your argument? That the NYPD? That's exactly what you just said.
No,
right?
not
because the defendant gets it, then everybody else should get it, right?
Well, yeah. So that last caveat that you said.
That's what you said. I'm only repeating it.
No, Judge,
I'm agreeing with you.
I agree with you because that's what the Court of Appeals said in Lesher. In Lesher, if you read Lesher, and if you read Abdur Rashid, the whole case is about. In the city use these words, tipping the hand of the prosecutor. The whole premise of interference by the legislature in the context of FOIL is that you're going to tip the hand and give an unfair advantage. If you don't have giving an unfair advantage, the whole interference doesn't exist. But my criminal analogy, Judge, you picked up on it. It's not even really so good because it's really stronger here because of 66A. I mean, so 66A, Committee on Open Government, that the statute under public officers law said unless it's not irrational, the second department said we defer to Committee on Open Government's interpretation of anything with FOIL. They said if you have a pulse, you're entitled to an accident report under 66A. You're an interested party.
So counsel, TVB are open proceedings, right?
Yes, Your Honor.
So you would be able to go to the proceeding and attend, right? They presumptively open.
Absolutely.
So you're saying basically the motorist, they already concede that the motorist is entitled to the document.
Correct.
So there's no reason why you should not have it. That's
right. How could you have interference?
Right.
And the whole and that's why I started addressing to Your Honors the backdrop from the Court of Appeals consistently about what interference means. Interference means you're going to give an advantage to the charging party. If there's no advantage being given to the charging party, these are documents that you have to release. I'm sorry, Judge, I see you want to ask something.
I just want to ask you, you didn't just ask for the accident report, right? You asked for notes. You asked for interview notes from the detectives to all of their everything that was going on. It's not like you just said, give me the MV,
That's correct.
You asked for investigative reports. You asked for the video, any video. You asked for any interview notes.
So let me.
What is your interest in all of that? What possible interest do you have in all of that?
So Judge, I agree with you, but to say nothing is an inappropriate.
Let me just ask you first and answer it. What's your interest in getting the detective's internal interview notes and thoughts and processes about how to prosecute this case? What's your interest in that?
Well, there was no criminal matter, so there was no real prosecution. So it was really an accident report in a video, which the Court of Appeals in Gold says is a factual thing, is the same as witness statements, which is all subject to FOIL. It's not exempt under intra-agency or anything else because it's factual data.
And you don't disagree that after this is over, you can get that. It's just at the point when the person's being prosecuted, right?
So, Your Honor, actually, I think the city put in something that it is over. But under this exemption, you're right, but that doesn't mean the city, the NYPD, won't raise another exemption. Apparently, there's some journalists that think once you have a case, go, because just because this one's not necessarily relevant, they may later say, oh, you can't have it for a different reason. But you're right, arguably, in a vacuum, yeah, they should have given it now anyways, because they say it's over and they still won't release it, which in itself is suspect.
Yes, you've indicated that there is a correlation between this case and cases that are criminally prosecuted. And I guess you're suggesting that this will be used to piggyback into a FOIL request in criminal matters?
I just wanted
where you would be entitled to documents and records and tapes and so on in a criminal prosecution?
So that's a good question. I mean, I guess what I'm looking for is, in a way, what I'm looking for is the court to identify what it means interference. In other words, all the case law from the Court of Appeals up until now says interference means that you're going to give an advantage to the charged party. That's not relevant here. So any case where that's not relevant, that you're going to give an advantage to the charged party. An investigation, by the way, is also under 87(2)(e), but it's totally different. This is about a proceeding. But yes, I would think that with any proceeding, it would be the same principle. I mean, you can't have interference if the charged party has the information.
Okay, thank you, counsel.
Could I just address the other prong with the judicial? Okay.
No, you don't need the other prong.
Okay.
And we gave you already 10 minutes on this one, so we gotta.
I'm not complaining.
So let me hear from the city.
Good afternoon, Your Honors, and may it please the court. This is Philip Young on behalf of the NYPD.
So counsel, two questions. Is your adversary correct that it would be that the motorist would have access to this information and all of the information, not only the MV, whatever, 104, what have you?
Yes, Your Honor. My understanding is that under Section 66A, the NYPD would provide most, if not all, of these documents to the motorist.
So I read in your brief that one of the issues is that you fearful of people, learning about their testimony or being able to kind of couch their testimony to fit with the documents that are being provided. So what is the difference between giving these documents to the motorist, who I'm assuming then could give it to the Jewish press or anyone else, as opposed to just giving it straight to Jewish press or to whomever is requesting the materials?
Yes, Your Honor. Well, yes, theoretically, the motorist could provide these documents to Jewish press. But I think there is a substantive difference between providing these documents to the motorist, which is allowed by statute and is a narrow exception to the interference concerns that have been raised here, versus providing these documents to Jewish press.
I just don't see what the difference would be. I mean, it's not like, I'm assuming that when you turn them over to the motorist, you're not stating to the motorist, and these are for your eyes only. Only you and or your attorney can have access to these documents, and you have to promise, you have to ensure that they're not going to be turned over to anyone else. So I do not see the difference. If you are providing the documents to them without any provisos or limitations, then why not provide them to other individuals such as Jewish press, etc.?
Well, Your Honor, as an example, one of the two interference concerns that the NYPD raised here was the risk of interfering with the independent recall of witnesses. And so let's say the Jewish press takes this, they take all this information, as Judge Scarpula pointed out, Justice Scarpula, there's a huge volume of reports and witness statements and all this, and say they write up a story. Then potentially, if there are witnesses to this accident that would be testifying at the TVB hearing, they might read that story and get inside information about what other witnesses are saying about the accident, and may shade their testimony accordingly. And it's those types of things.
Isn't that what cross-examination is about? And I mean, with all due respect to the Jewish press, I mean, it's not like it's a New York Times or read by millions of people, right? So you know, wouldn't you be able to, in the context of cross-examination, ask the witnesses, have you seen any, have you read any reports with respect to this incident? And ask all of those questions that would allow you to then determine whether there has been interference. I mean, particularly when we're doing the balancing, and the balancing is a pretty fundamental right on the part of the Jewish press to have those documents are presumptively open, right?
Yes, the documents are presumptively open, but again, remember that while the burden here is on the NYPD, the Court of Appeals has said that it's a relatively low burden. It's just identifying the documents that are subject to the exemption and then identifying the generic risks that arise here. So yes, while it's certainly true that the TVB's prosecuting officer could cross-examine and try to learn some information about these witnesses as to whether they had seen these articles and had their perspectives colored by them, it's certainly reasonable for the NYPD to look at this and say, you know, we're concerned that disclosing this to an independent press group is going to possibly result in interference in the way that these witnesses.
Yeah, that's a broad that's a broad reading of interference, as I read it in Lesher and in Abdul Rashid.
So, Your Honor, the other point I guess I would make about this is it's certainly true that Lesher and Abdul Rashid both involved criminal cases and prosecutions, but the FOIL exemption here was modeled after the Federal Freedom of Information Act, which federal courts have consistently and repeatedly held apply to other types of administrative enforcement proceedings outside of the criminal context. They apply it very broadly.
So, and I don't dispute that. That's why I think Mr. Aaron's argument with respect to whether this is a judicial proceeding or not is not that strong. But they do have a strong point on that second element, namely the interference element. And I just don't see it. I don't, the stuff that you're raising with respect to interference seems to me very speculative and stuff that can actually be resolved in the context of examining the witnesses that you feel will be interfered with by Mr. Aaron or anybody else.
I understand, Your Honor, but again, the burden here on the NYPD is quite low. It's identifying generic risks that in the NYPD's eyes could apply to a proceeding like this. And once the NYPD identifies those generic risks, it's satisfied its burden under the judicial interference exemption.
A low burden is still a burden. And so you still have to meet the burden. So yeah, I still do not understand how you make out interference.
Well, Your Honor, I guess
there's so many other ways to counteract your concerns concerning, tailoring testimony by cross-examination. I mean, is that it? Is that the only thing? Is that the only definition or fear in terms of interference?
Those are the interference concerns that the NYPD identified, and so that's what we have, and that's what this court has to consider when it's analyzing the judicial interference exemption. But
okay. We will do that, Mr. Young. Thank you so much.
Thank you, Your Honors.
Okay, Mr. Aaron, you got 1 minute.
I'll speak quickly. Thank you, Your Honor. I just want to say two things. First of all, the record doesn't even reflect that there were witnesses in this case, I don't believe. So, to go back to what I was asked earlier, while some of the records, I don't know if there's witnesses or not. Well, actually I do. I think there were, but while some of the records may be able to be withheld, others may not. So this blanket withholding either which way, I don't think is appropriate. The other point I just want to address is about the generic risks, and I think it's a big misstatement of the law. I don't think that generic risks alone are adequate. I think specifically the court said in Lesher in the Rashid case was about Glomar with like national security stuff or whatnot. There you could use a generic risk because anything with any particularity itself would give away the, would sort of give it away. But in a general case, you would need to show with particularity. So I think I didn't misspeak. The record does show that there are witness statements. But I think you still
even if you were, Mr. Aaron, even if generic risks were the way that Mr. Young described them, they certainly cannot be speculative concerns. That's not the equivalent. Agreed.
Correct. Not speculative. That's the wording.
Okay. Thank you so much.
Okay. Thank you all. Have a good evening and happy holidays.
Thank you, Your Honor.
Holidays. Okay, last, Share versus Turin Housing.
Good afternoon, Your Honors. Mark H. Bierman for the appellant plaintiff. Can everyone hear me?
We can hear you, Mr. Share.
Bierman, Your Honor.
Bierman, I'm sorry.
I know it's a long day.
I've seen you argue before so many times, particularly on this case, that I should know that better, right?
Thank you, Your Honor. Your Honor, the sole basis for the summary judgment motion in the court below was directed to the pleadings, asserting that that the pleadings stated a derivative action and that the required demand had not been made. This was incorrect for a number of reasons. The plaintiff in this case was asserting that the cooperative board was continuing to assert, contrary to its lawful authority, restrictions on sale prices, was seeking to put further restrictions both on sale prices as well as the use and occupancy of his property. The allegation was basically that this was impacting on the use of his property and in that of the putative class members. It was basically seeking declaratory relief with respect to those restrictions, with the right of the co-op to continue negotiating in the face of a shareholder vote that said it could not for a further regulatory agreement, as well as declaring a vote that was taken that related to the regulatory agreement and amendment of the certificate of incorporation to allow such a change that was an invalid election. With respect to
Mr. Bierman, I let's assume for the moment that there was a pre-litigation demand. How is Mr. Scheer a proper representative of the class here?
Mr. Scheer is a proper representative of the class because number one, he is a shareholder. He's been a shareholder for now almost 50 years. He has served on the board. He has a PhD in economics. He has the resources in connection with the litigation, and he has the support of many of the shareholders in connection with this. His claims are representative of all the other shareholders. Basically, they're facing the same thing. This is an extraordinary situation. This co-op.
Counsel, I don't understand. The vote was 126 to 22. So how is he representative of all the shareholders?
Well, that goes to an essential element that was not even addressed by the court below, which was part of the claims was a declaration with respect to the validity of the election. In the bylaws, there were a whole host of infirmities in that election. Chief among them was, number one, that over a third, approximately a third or more that we know of, were voted by unlawful proxies. The bylaws were...
That's not making sense, counsel, because Mr. Scheer himself was the bearer of proxies, and he cast ballots for those people.
Mr. Scheer voted proxies in accordance with the provisions of the bylaws. He voted for family members, and I think he voted for one person who was not married, which was in accordance with the bylaws and with the traditions and practices of the corporation.
Mr. Chairman, this is Judge Scarpula. How is Mr. Bierman different from any other shareholder? Every shareholder would suffer the same damage if the shareholder vote was improper. Every single shareholder would suffer that same problem. So when every single shareholder suffers the same injury from the actions of the board, that's classic derivative. How is this not classic derivative?
Well, I think classic derivative is when every shareholder suffers a diminution in the value because the corporation does something that's reducing the value of the corporation. That's not what the claim is here.
No, the claim is the wrong, and the wrong was suffered by every single shareholder equally. And their damages may be different because sometimes someone holds 3 shares and someone holds 100 shares. But if the wrong goes to all the shareholders equally, all the shareholders, that is, I promise you, a classic derivative claim.
Well, except, Your Honor, I think that those are the elements for certifying the class, which was not disputed. I mean,
that's not what Udell said.
It's direct or derivative. If every shareholder suffers the same injury, it's not a direct claim, it's a derivative claim. The number of damages might be different, but it's clearly a derivative claim. I mean, that's not even, I don't think that's a controversial statement.
Well, I think it, respectfully, Your Honor, I would disagree because that may be true when the harm is that's being alleged is to the corporation. There's no harm being alleged to the corporation here. There's no remedy sought on behalf of the corporation. There's no damages sought. It's all on behalf of the individuals who will lose, like you said, various amounts of money in connection with the sale of their apartments. I mean, it really is sui generis when you have shares in a cooperative corporation that have also characteristics of property as well.
But I thought that I thought, you know, I don't want to repeat what Justice Scarpula said, but I thought that the core of your claim are a diminution of value in the proprietary shares that are pertinent to the apartment, and that is exactly what Udell, for example, as early as 2012, our decision held was classic derivative.
Well, Your Honor, I think that what was being alleged here in terms of those damages it didn't go to, there's no intrinsic value to these shares. It goes to the ability to sell an apartment. It's very different from any, I think, from any other cases that are decided generally in the corporate realm. But I do want to say that even if assuming
is Mr. Scher able to sell his apartment at a much higher, I'm going to call it rate of return than everybody else because of that settlement?
No, Mr. That was, I think that was something that was a misrepresentation. Mr. Scher was not a party to that settlement. Mr. Scher was not a party to that litigation. There was nothing that affected his apartment. He didn't waive anything. He didn't stipulate anything. So I think that was what the court below said, basically cited a whole bunch of cases that he was not a party to, and as a basis for saying he was not a class rep. But let's say for a moment, Your Honor, as you said, let's say that this is a derivative action. I mean, I can read it directly, but it's in the record on our 863. Our letter of May 10th says, stop it, bring an action, and it couldn't be a more classic demand that satisfies the not-for-profit corporation law as well as the BCL, and their response was it's gibberish and went on to do what they wanted to do.
Yeah. So thank you, Mr. Bierman.
Thank you, Your Honor.
Okay, let me hear.
Your Honors, can you hear me?
We can hear you, Mr. Finney.
First, I would like to say, may it please the court, I want to thank Your Honors for your judicial service in a pandemic. While we're all suffering in some ways, these types of oral arguments we'll always remember, all of the attorneys will remember that you kept the wheels of justice moving. So I really want to thank you for that.
Thank you.
Your Honors, one thing I did want to just immediately address was that Mr. Bierman said that Mr. Scherer was not part of the settlement. At the record at page 560 in front of the federal court, Mr. Scherer was in the room, and at page 572 of the record, the court said at page 572 of the record, and Mr. Scherer, for your family interests in connection with the state court matter, are you authorized and do you agree to the settlement? And he said, yes, I do, and that's in the record.
Well,
Now,
that's not really relevant, counsel, right? I mean, either he has direct claims or derivative claims.
You're on, absolutely. The reality is that the lower court applied clear law, correct law, that this is a quintessential derivative claim, and the court properly ruled. I did want to point out a couple of things, though, Your Honor. This plaintiff purchased into an affordable housing building under which its certificate of incorporation, the record is at page 729. It makes clear that this company has been organized exclusively to develop on a nonprofit basis housing for people of low income. And what this case is about is his attempt, after he bought into into an affordable housing building for people of low income, he wants to now overrule the board's business judgment to enter into a new regulatory agreement with the city of New York and make a profit and sell it at market prices. That's not the building he bought into. The board is well within its judgment to decide to enter into a deal with HPD. And what he tried to do with this litigation is he tried to file a class action to thwart the board. And by choosing that procedural vehicle, he bypassed what he would have to do is make a demand. If he had made a demand and said to the board, you now need to sue yourselves. You need to sue yourselves for exercising your business judgment. Mr. Catafago, my partner, and I would have put together a special committee, a litigation committee of that board. And then that committee would be entitled to business judgment as to whether.
Counsel, Mr. Feeney, did the plaintiff plead that a demand was made in the complaint?
It was insufficient under case law. The demand that he made, what he alleged his demand was, well, we complained to you. That's not a demand. Right. A demand, so he did not properly plead demand. And if he had pleaded, and the reason why he didn't ask the lower court to amend his pleading and now make it a derivative action is he knows that. He knows that if he makes the demand, that Mr. Catafago and I will impanel a special litigation committee, and then that committee will be entitled to deference under business judgment. He doesn't want to do that. He wants to stifle the board in an affordable housing building with a massive class action, and the lower court was 100% correct in dismissing this action.
Thank you, Mr.
Unless you have
Feeney.
any questions, Your Honor,
I think we're good. I think we're good. Mr. Bierman, you get 1 minute. Mr. Bierman, you are muted.
Sorry, Your Honor. I think that what counsel said is actually important because, first of all, this was a low and moderate income under 221D3. The part of the basis for the claim is that all of those restrictions ended in 2012, and there are no other restrictions that are in place now. So I think it was an incorrect statement of what the status of this cooperative is. It's undisputed that there was a vote against negotiations with shareholders, and the court below so found. So the question becomes, was there a valid vote of the shareholders to go forward with this, which we've shown enough evidence that there was not, and that's not something that was the grounds for the motion. It's not what the court below didn't rule on that in any way. It just dismissed all of the claims. And I just want to say lastly is that even if the court were to find if these were somehow not, that there shouldn't be a class here, well, there was not a reason for his dismissal of his individual claims. His shares are being impacted. What other remedy does he have except to go to court and say the board is acting outside of its authority and cannot do this? And with that, I thank Your Honors. I rest on the balance of the brief, and I wish Your Honors a safe and well holidays.
Thank you, Mr. Bierman. Thank you both. This concludes this session of the Appellate Division First Department. Thank you for your attendance.
Thank you.